इयरफोन इयरफोन Deepa ma'am, shall we start?
Yes, Srini, start.
Most Reverend Mother Mary Francis, Most Reverend Mother Mary Francis, Mother General CR and Manager All Saints College, respected Principal All Saints College Dr. Deepa M, Member Secretary Kerala State Higher Education Council Dr. Rajan Verghese, resource persons of the webinar, IQAC Coordinator Dr. Anjana PS, colleagues, dignitaries and participants. A very good morning to one and all. In every day, there are 1,440 minutes to 40 minutes for each person. That means we have 1,440 daily opportunities to make a positive impact. Today, we all are here on the virtual platform for the one-day national webinar on intellectual property rights and protection, organized by the IQAC of All Saints College, Trivandrum, in academic collaboration with Kerala State Higher Education Council. Briefing about the program. First, we have the inaugural session, followed by the sessions on IPR and protection by eminent resource persons. A few participants, kindly mute your mics when you are not asking any questions, and unnecessarily please do not press the present now option on your screen to avoid the disturbances for the presentees in between the presentation. Let's begin the inaugural session by invoking blessings from God Almighty. Prayer by Ms. Aparna Malik.
Read kindly light amid the encircling gloom, lead thou me on. The night is dark and I am far from home, lead thou me on. Keep thou my feet, I do not ask to see the distance in one step enough for me. So long thy power had blessed me, sure it's true, will lead me on. Oh, and fine, oh, cracked and torrent too, the night is gone. And with the moon, those angel faces smile, which I have loved long since I lost a while.
Thank you, Aparna. Dr. Anjana PS, Coordinator of IQAC, All Saints College, will now welcome each one of you to the national webinar.
Thank you, Sini. Respected Principal, Dr. Deepa M. Esteemed guest, Professor Rajan Verghese, Member Secretary, Kerala State Higher Education Council and former Pro Vice Chancellor, MG University, and dear participants. I'm happy to welcome you all for the national webinar on intellectual property rights and protection in the interest of the entire All Saints fraternity. As all of you know, universities and public research institutions are among the direct contributors towards innovation and research, particularly in emerging economies. The potential pool of talent for innovation emanates largely from educational and research institutions. Though late, the significance of intellectual property rights in higher education has been widely recognized, and hence national IPR policy has been approved by the Government of India in 2016. In addition, the National Institutional Ranking Framework and the National Assessment and Accreditation Council rankings acts as a mechanism for the institutions to include promoting innovation, research and development while assessing their performance beyond academics. One of the parameters considered while ranking and which is significant to our discussion is research and professional practice that includes IPR and patents, both published and granted by students and faculty members. Moreover, the UGC, the nodal authority for determining and maintaining of standards of university education in India, had issued a letter for inclusion of the intellectual property rights as a generic elective subject under the CPCSS system. It has also been encouraging students to understand the importance of startups, thus directing their focus towards entrepreneurship. An active collaboration between the student and the university leads to growth, development, and healthy commercialization of the invention conceived in the campus. Hence, the need of the hour is to give an awareness of the various IPR to the faculty and students of higher education sector, and our humble effort for this comes true. Before we kickstart this function, I, on behalf of the entire faculty members and students, would like to welcome our guest of honor, Dr. Rajan Varghese, for taking his precious time out and gracing the occasion with his presence. Even though he needs no introduction, it's my duty to say a few words about his achievements. Dr. Rajan Varghese is currently Member Secretary of the Kerala State Higher Education Council and was the Pro VC of the Mahatma Gandhi University, Kottayam during the period 2009-2012. He was also the head of the PG and Research Department of Economics of Union Christian College, Aluva, and he has 33 years of teaching experience and 22 years of research experience. A postgraduate in economics from University of Kerala, continued his studies in Cochin University of Science and Technology, where he secured PhD. He was the chairman of the subject committee on education of the Kerala Shastra Sahitya Parishad, and he headed several important academic and administrative tasks in MG University. He was in charge of the entire university examinations of nearly 350 affiliated institutions. As a Pro VC, he was the chairman of the University Level Monitoring Committee, which successfully implemented the choice-based credit semester and grading system at the undergraduate level in 2009. He was also the chairman of the implementation committee for the single window system of admission called the centralized allotment process. And he was the general convener of the first international book fair organized by the Mahatma Gandhi University in January 2012. He was active in the state level committees related to higher education and planning, Committee on the Cluster of Colleges Scheme, Committee on Higher or Technical Education, Review Committee of Credit Semester Programs of PVC, etc. He is actively associated with other universities in the state in the realm of curricular reforms. As member of Board of Studies, Task Force on Grading and Faculty of Humanities of various universities in Kerala. He is actively engaged in research in his capacity as a recognized research leader of Mahatma Gandhi University. He completed 2 projects and has published 2 books on university administration, on autonomous colleges, and having nearly 27 articles in journals and periodicals to his credit. I will welcome you, sir, for the webinar. Next, I welcome our principal, Deepa Ma'am, who has been the driving force behind this whole process. Fortunately, we have with us today eminent personalities as resource persons. Dr. Tammaya Ramakrishna, Professor in Law, DPIIT Chair on IPR at National Law School of India, University, Bangalore. Dr. Ajit Prabhu, Chief Scientist, KSCST and Nodal Officer, Patent Information Center, Kerala, and Dr. Lisa Joseph, formerly of Intellectual Property, Department of Royal Philips, Bangalore. We understand that you all have taken time out of your very important schedules to contribute to this webinar. Welcome you all. I would like to welcome all the participants. Your active participation is important throughout the session. I ensure the seminar will be profitable and the next few hours will be enjoyable and fruitful for everyone. Thank you. Thank you, Ananto.
Thank you, Anjana. May I now request the Principal, All Saints College, Dr. Deepa M., to deliver the presidential address.
Thank you, Sini. Good morning to one and all. Dr. Rajan Varghese, sir, Member Secretary, Kerala State Higher Education Council, Dr. T. Ramakrishna, Dr. Ajit Prabhu, Dr. Lisa Joseph, all the IQAC members of All Saints College, all the faculty members, and my dear students. Intellectual property refers to creations of the mind, such as inventions, literary and artistic works, designs, symbols, names, and images used in commerce. In today's economic environment, intangible assets are becoming increasingly important. Intellectual property is protected in law for patents, copyright, and trademarks, which enable people to earn recognition or financial benefit from what they invent or create. By striking the right balance between the interests of innovators and the wider public interest, the intellectual property system aims to foster an environment in which creativity and innovation can flourish. India's intellectual property legislation covers every significant aspect of the protection of intellectual property. It is essential to protect intellectual property rights through intellectual property registration, followed by a long due process of corroborating the authenticity of the creation. Intellectual property is thus a strategic asset for industry and public health. The growth of new global public-private partnerships have shown that management of an intellectual property system is essential. In today's century, Gen Y is considered the key person for laying down a future roadmap for creating, nurturing, building, and strengthening creativity and innovation. In this regard, student-focused policies ensure that a change is initiated and supported by students, especially in light of envisioning a young and healthy, creative and innovative startup ecosystem. The R&D facilities, infrastructure, and other amenities provided by the academic institutions offer a platform for students to build and sustain this environment. The foundation of this has to be laid at the grassroots level by initiating programs for the youth with specific target being the academic institution. Intellectual property cells can be created in academic institutions, and IP cells envision promoting academic freedom and safeguarding the interests of the inventor in creation and commercialization of intellectual property with legal support. They also envision promoting an IPR culture compatible with the educational mission of the academic institution. IP cell can ensure strategic factors, and the students can be encouraged to perform in the IP cell and thus grading the academic institution IP cell activities also. Thank you.
Thank you, ma'am. On behalf of IQAC and all present here, may I now request our guest of honor, Dr. Rajan Varghese, Member Secretary, Kerala State Higher Education Council, to inaugurate the national webinar by inaugural address.
Hello. Good morning to all. In fact, I am very happy and in a sense privileged to associate with the academic activities of All Saints College Thiruvananthapuram, which has emerged as a major seat of learning in this part of the country. This is mainly because of the tremendous effort of the college authorities, especially of the teachers. And I, at the outset, congratulate the principal and the faculty members of the college for organizing such a webinar of this sort. I am very happy that we have the principal, Dr. Deepa M, the IQC coordinator, Dr. Anjana PS, and we have eminent resource persons from the country, especially from the National Law School, which is a major seat of learning as far as law education in the country is concerned. It's a model to many institutions in the world. Dr. T. Ramakrishnan, and also the chief scientist from the KSSPE, Dr. Ajit Prabhu, and Dr. Lisa Joseph. And as noted earlier by the principal, the idea or the debate on intellectual property right in relation to higher education is a new thing as far as the academics or institutions in Kerala is concerned. Actually, intellectual properties are products of human intellect that are unique, new and innovative, have some value in the marketplace, and are the creation of a single person or a team. Intellectual property can be an idea, an invention, a patented work, an expression or literary creation, a copyrighted work, a trademark, an industrial process. A composition of a matter can be a medicinal formulation, a computer program, a presentation, or a data of a digital magnetic origin. And in recent years, intellectual property has become increasingly important to academic institutions throughout the world as research initiatives continue and expand, in part based on accreditation requirements. Old and new issues arise regarding research discoveries. These issues include private sector participation or sponsorship of university research, issues related to ownership of research discoveries, dissemination of new knowledge, and technology transfer policies. Also at issue today is whether universities will allow commercial forces to determine their educational mission and academic goals. Actually, this is happening at several levels. Even the curriculum is being influenced by commercial forces because they want to get the product of public investment for their private employment. Interaction and collaboration between university scientists and private firms have become the norm in many educational research facilities. Because of that connection, scientists today are well aware of the opportunity for financial incentives and security based on commercial success of licensed products, which can result in a continued debate over the ownership of intellectual property. And about higher education institutions in particular, we know that discovery and knowledge dissemination has always been a key component of higher education or the university mission. This dissemination of knowledge in the form of high quality academic publications, abstracts, conference proceedings, and invited presentation is a measure of success both for the university and for the individual researcher. Knowledge generation and transfer is what we as academics do. It is our core business. However, this core business has been under challenge while basic scientists would submit that discovery and knowledge dissemination rather than profits should be the focus. Today, teaching and research institutions not only aim to serve public interest with educational objectives, but also focus on the receipt of revenue through the exploitation of intellectual property created by universities or by academics. The primary justification for adding commercial value as a component of university education relating to dissemination of knowledge is that it promotes technological development for the benefit of society as a whole. Yet, commercialization of research discoveries has in many cases discouraged the dissemination of knowledge in the public domain for the purpose of delaying the release of codified knowledge in scholarly publications in order to protect the novelty of patentable inventions. Some of the multinational companies, they purchase patents, but they keep it for a long period to release it for maximizing their profit. So this problem is there. In such cases, it is profits, royalties, or licensing agreements that drive research or the university research mechanism, not research for the sake of research. Faculty who in previous years may have been hired for teaching skills or basic science research ability may now be hired with a focus on expertise in a particular field for the specific purpose of developing intellectual property that can result in commercial application. Higher education no longer sees itself as being devoted mainly to education and research. Today, higher education also sets policy to assure commercial application of intellectual property. But the situation in our country, I was elaborating on the general trend all over the world. But higher education in the country, especially in our state, is suffering from several deficiencies, especially with regard to the level of research. Recently, we have published a document. Actually, the document was perfected by Dr. Gangan Pratap, a leading scientist in the country. And he says that for a state like Kerala, we need to produce at least 5,400 PhDs every year, especially in the science technology stream. Today, we are producing, the state of Kerala is producing annually only 1,600 PhDs. So if you want to increase the pace of economic development or human development, you have to increase your investment in higher education, especially in research. There are several efforts at the national level to increase the resources for research. We nowadays spoke about the National Research Foundation, which is going to earmark a sizable amount of its country's GDP for research. This will actually open a new avenue for research in the universities and in the colleges. But in the state of Kerala, our universities are not figuring in international or, for that matter, national ranking, although one or two universities are listed, and only limited number of our professors, academics, they figure in the national list of eminent researchers. And there are several innumerable problems for teachers in affiliated colleges, where in affiliated colleges, teachers are actually destined to conduct classes, and research is of a very low priority, not because of their neglect for that. The situation prevailing in most of the colleges, because of bureaucratic control and regulation, is not conducive for research. So the council is actually making every effort to increase the quality of teaching learning in higher education institutions. Similar to the national institutional ranking framework, we are also trying to prepare a state level Kerala state institutional ranking framework, which will take into account the contributions of individual institutions in higher education, especially in research. Similarly, we are providing training to teachers And these training sessions are actually led by eminent scientists from different parts of the country, including IISc Bangalore. And we have also a program for inviting eminent persons to our campus. Today it is hindered by the COVID, but that scheme has been utilized by several colleges. It's called the Scholar in Residence program. So I request and I solicit the cooperation, the entire academic community and the college authorities to make use of the opportunities, though it is limited in our state, for increasing or strengthening the resource base and also the research activities in our universities and colleges. I conclude at this point because we have eminent resource persons to deal on this subject. There are several issues related to IPR. So as a student of economics, I have some points to make on that, but my intention is to confine to the short speech as the inaugural speech. And I thank the college, especially the principal, Dr. Deepa, and all the faculty members for giving this opportunity for participating in the webinar. And I also I greet all the resource persons, especially Dr. Ramakrishnan from National Law School, Bangalore, for joining hands with our colleges and our faculty. With these words, I inaugurate the national webinar organized by the College, Intellectual Property Rights and Protection. Thank you all.
Thank you, sir, for explaining to us in very simple words what IPR is, the importance of IPR in education system, the importance of research in IPR in educational institutions in very, very simple words. Thank you so much, sir. Now, may I request Dr. Srilekha Nair, Head of the Department of Commerce, All Saints College, to propose a vote of thanks.
Respected Member Secretary, Kerala State Higher Education Council, Dr. Rajan Varghese, other distinguished guest speakers, respected Principal Dr. Deepa Ma'am, IQAC Coordinator Dr. Anjana PS, other members of IQAC, colleagues, and my dear students. It's an honor to have been asked to propose a vote of thanks on this august occasion. We offer our sincere thanks to Dr. Rajan Varghese for kindly accepting our invitation and gracing the inaugural function. Sir has shared his valuable thoughts, and that will no doubt serve us on the good step. Thank you, sir. Thank you, everyone.
Thank you, ma'am. With this, the inaugural session is over. Now, I request Dr. Reshma J.K., Head of the Department of Environmental Science, to welcome and introduce the speaker of the session.
Am I audible?
Yes.
Professor Dr. T. Ramakrishna, Dr. Deepa, our principal, Dr. Anjana, IQAC team coordinator, the entire IQAC team, dear colleagues, participants from various colleges and other institutions, dear researchers and students, a very warm good morning to one and all. As you all know, we are eagerly waiting for the first session of the webinar on IPR and protection, which is organized by the Internal Quality Assurance Cell of All Saints College in academic collaboration with the Kerala State Higher Education Council. This session will be handled by Professor Dr. T. Ramakrishna of National Law School of India University, Bangalore. I feel greatly honored to welcome him for this program. Before entering into the official duty of welcoming him, I would like to give a brief biodata of Professor Dr. Ramakrishna. Professor T. Ramakrishna holds the DPIIT chair on IPR under the Ministry of Industries and Commerce, Government of India, at National Law School of India University, Bangalore. With 4 decades of teaching experience so far, he has also been heading the Center for IPR Research and Advocacy, which is popularly known as CIPRA, which is an Institute of Excellence on IPR and Standards at National Law School of India University, Bangalore. And he has several publications, both national and international publications to his credit. And he has extensively traveled and participated in international conferences on IPR. And he is involved in DST patent facilitation programs and MSME IPR programs. Coming to today's session, Professor will be talking about copyrights and trademarks protection in India. For students, budding scientists, and faculty present here, knowing about copyrights and trademarks is highly relevant and is an ideal topic selected for today's session. So we are greatly honored to have you here for today's session, which is organized by the IQAC of All Saints College. With these few words of introduction, let me formally welcome Professor Ramakrishna for today's session. On behalf of all participants present here, on behalf of the entire IQAC team of All Saints College, and my own personal behalf, and a very warm welcome to you, sir. And thank you all and have a nice day ahead.
Principal
take over the session.
Am I audible?
Yes, you are. You are audible, sir. You are.
I'm audible. Yeah, I'll be sharing the PPT, and my request to Saini or Reshma, kindly tell me if the slides are not moving, number one. Kindly also inform me if I'm not audible. Right?
Yes, sir. Sure.
The principal of college, Professor Deepa, the member secretary who gave a wonderful, excellent introduction, setting the tone for the entire program, of telling us about the role of higher education, especially in research and in the economic development. The role in economic development and the role of research activities in higher education. He was so candid that there are institutions which need to bolster up. There are faculty members who, despite their inclination to do research, will not be able to do research for various reasons. He was also emphasizing on the kind of publications that are coming out of the universities and the drawbacks of non-publication at the earliest point of time. He emphasized on the point that because novelty is likely to be lost, most of the publications do not get published at the earliest point of time. And there are also instances where it's going to chill the research activities or academic activities. He has brought before this particular August gathering the real facts and real situations prevalent in most of the academic institutions. We know most of the researchers end up as academic researchers with their discoveries, end up as academic researchers with a main aim of obtaining a PhD and a career advancement. But many do not realize that the research that they have done has within it a lot of IP potential, and that IP potential will have to be exploited. And that's one of the reasons why these types of programs are being held. Principal also emphasized on the IP cell of an university. The IP cell of an university should take care of protection of the IP in that particular institution. the entire administrative responsibility should not be shifted to the academic researcher. Academic researchers' research is only to do research, find out the results, and there should be a body which should support the academic researcher in converting that particular research outputs into a economically viable intellectual property rights. And therefore, the role of IP cell becomes very, very important. But there are also institutions in which academic researcher, by virtue of the area that he has selected, by virtue of the invention that he makes, would get himself transformed into an academic inventor. And in most of the cases where university supports a spin-off or a startup, I am sure this academic researcher would translate or transform himself not only into an academic inventor, but also become an academic entrepreneur. So he continues to teach. He gets that experience of the entrepreneurship. He gets the experience of knowledge transfer from desk to industry. And that experience he'll be able to bring it back to the class and thereby further promote the research activities. And in that context, let me at the outset congratulate All Saints College of Trivandrum in initiating this particular program. Let me also thank at the very outset Dr. Anjana for having given me this particular opportunity, and my learned friend Mr. Jaya Krishna, who is part of this particular institution, for having introduced me to this particular institution. I will not be speaking on patents as such because my topic that has been assigned to me is trademark and copyright. Let me just confine myself to that. Although I am prompted after the speech of Mr. Rajan Verghese to speak about patents. Ms. Reshma, can you just allow me to share the screen? I'm unable to share the screen here.
Sir, please click on the present now option.
No, that's not opening. That's the reason. You may have to.
Anjana?
That's blocked.
Anjana?
That is blocked from my side.
1 second, sir, please.
Yeah, now it is done.
Yeah.
Now we have.
Yes, sir. Now it's enabled.
Yeah.
Sir, is it okay, sir, now?
Yeah, it's enabled, madam. No problem.
Okay, sir. Okay.
Reshma, is it visible?
No, sir.
Yes, ma'am.
Law of trademarks. No?
No, sir.
No, sir.
Maybe I'll share it again.
Yes, sir.
Now?
No, sir.
No? Okay.
1 second, sir. It will be coming. It will come 1 second. Is it coming, sir?
Yeah, now it's.
Yes, ma'am.
No, sir. It started streaming, but now the screen is not visible. Your presentation is not visible. You can try it once again.
It's visible. Sir, it's visible now, sir.
Yeah,
Okay, friends. In case it freezes, kindly inform me. I'll stop and then go back. The law of trademarks, or the trademark protection as we call it, is a very, very important factor to be considered by any commercial establishments, any industry, whether it's a small-scale industry or a multinational company. The reason is this trademark acts as a link between the producer of the goods and the ultimate consumer. How does it act as a bridge? It is going to communicate to the end consumer the quality of the product, nature of the product, as well as the source of that particular product. And from that perspective, trademark becomes important in the industrial arena. Let me just start off with a statement by Justice Frankfurter in one of the case Mishawaka Rubber and Woolen Manufacturing versus SS Gracie. If you can just see this particular slide here, this is what Justice Frankfurter said. A trademark is a merchandising shortcut which induces a purchaser to select what he wants or what he has been led to believe he wants. So as far as the purchaser is concerned, trademark is a merchandising shortcut. So he can select what he wants and what he has been led to believe he wants. How does the owner exploit it? The owner of a mark exploits this human propensity by making every effort to impregnate the atmosphere of the market with the drawing power of a congenial symbol. So which means a symbol is selected by the owner of a particular property and he owns that particular mark and he knows that the symbol is capable of communicating the quality, the source, and the nature of the product to the end consumer. And he impregnates the atmosphere of the market with this congenial symbol. And when we see a particular symbol, immediately our mind goes back and then relates that to a particular product. On seeing the golden arched M, I am sure we will all be led to the McDonald's and the food that's going to be served there. The protection of trademark is the law's recognition of the psychological function of symbols. So symbols perform the psychological function, and therefore protection of trademarks is the law's recognition of such psychological function of symbols. Friends, all of us know this basic fact that symbols are the thing through which we reach out to the products. For example, the bald eagle. The moment you say bald eagle, it immediately suggests United States. The blind goddess, balance your scales, represents justice. The dove signifies peace. This is just to highlight the fact that symbols have the psychological function. Well, friends, if we are talking of the trademark, let me just give you the definition of trademark first, and then go through the other parts. What is a trademark? The definition goes like this. It is a mark. It should be a mark first and foremost. And the mark should be capable of being represented graphically. Then, it must be capable of distinguishing the goods or services of one person from those of others. So it is capable of being represented graphically. It is capable of distinguishing goods from one person to another person. Then, it may include shape of goods. You can have a shape, and the shape itself can become a trademark. Their packaging and combination of colors. This is broadly the definition of a trademark. But before I move on to explain you, I say what are all the aspects to be kept in mind when you go for a trademark registration, or the implications of trademark in your commercial activities. Let me just point towards this. See, all these are relating to the goods. So the material that is sold, Puma, the shoes, Adidas, the shoes, BMW, the automobiles, Starbucks, the coffee, Coca-Cola, right, the drink, and the food in McDonald's. These are all related to goods. When I come and explain you, I'll explain you that the trademarks are in relation to the goods as well as services. Both are covered under trademarks. And just see the list of trademarks which offer services. The internet services, search services by Google, IBM, product as well as services, Vita, it's just a service one, Facebook provides a platform for you, Amazon, its service, L&T service, NBC, and the organization that is the basis of IPR, the WIPO itself. These are all popular marks which are related to the services. But then, let me just start to tell you, whenever you think of a particular mark, you will come across three types of marks. One is a mark which is inherently distinctive mark. Second is a non-inherently distinctive mark. And third is a mark which does not have any distinctiveness at all. Let me pick up the first one. There are marks which are by themselves distinctive, and therefore automatically it becomes a trademark. And most of the industries would go in for inherently distinctive trademarks. The reason is they need not establish at a later stage that this particular mark has acquired the status of a trademark by acquiring secondary meaning. What are those different marks that you see? First categories are fanciful marks. When I say fanciful marks, example I have given here, Kodak, Ruticura, Xerox. See, all these are marks which were created for the purpose of being used in that particular product. They were invented rather. Those which were invented and which are unique, which were not used priorly, becomes fanciful marks. But then friends, there are dangers of using fanciful marks in most of the cases. The reason is that becomes the first product on which it's being used, and over a period of time, that name itself gets associated with the product, and as a consequence of which that particular name might become generic. Right? Aspirin, you have heard of aspirin. Aspirin was a trademark initially of Bayer, but over a period of time, everyone started calling every tablet relating to headache as aspirin. So now aspirin is no more a trademark. It may be used by the companies, but it's not used as a trademark by Bayer. Similarly, cellophone tape. Cellophone is no more a trademark. Walkman is no more a trademark. Right? Dalda is no more a trademark. So there are several such things which have lost the trademark status because they are no more distinctive. They are no more distinctive because they are not capable of distinguishing the product of one person from the product of another person. The reason is all those products are likely to be called by the consumers by the same name, cellophane. And that is also happening with respect to Xerox, right? When you just ask for a printout, you will not ask photocopying. You just ask, get me 4 Xerox copies of this particular thing. However, Xerox is trying to defend its trademark, especially in US and other developed countries, through several advertisements. Let me just point out to 2 advertisements that Xerox makes. It says, do not Xerox a Xerox on a Xerox. We don't mind you photocopying a copy on a Xerox photocopier. One advertisement which wants to keep Xerox as a trademark. Second advertisement of Xerox is, please do not use Xerox in the same way you use aspirin. You know, aspirin has become generic. And it goes ahead and says, if you use Xerox in the same way as you use aspirin, we get headache. So through that, they are trying to retain the trademark status. In case of fanciful marks, it's very good. It's the most strongest mark, but there's a danger of that particular mark becoming generic over a period of time. The second category is arbitrary marks. When I say arbitrary marks, it has a primary meaning, but when it's applied to the product, there is no relationship between the name and the meaning of that particular word and the product which is being applied. For example, apple. Apple, the primary meaning is something different. It relates to fruit. But apple has been applied to computer and the digital technologies developed by this organization. And it has grown in such a tall way that it has become one of the well-known marks and highly reputed trademark. Similarly, black and white. Black and white for Scotch whiskey. Black and white is a color. It is a primary meaning. But in the context of whiskey, it becomes a black and white and becomes a trademark. That's as far as arbitrary mark is concerned, friends. Next one is suggestive marks. When I say suggestive marks, these are marks which are going to relate to the product, but that relation to the product is a little slow because the consumer will have to imagine and then relate it to the product. Only then you'll be able to relate it to the product. Those are suggestive marks. For example, chew and clean, right? Dentifrice, stronghold for nails. Chew and clean for dentifrice and stronghold for nails. They're related, but not directly. Let me just give you an example of suggestive mark at this particular stage. All of us know hush puppies. What is this hush puppies that we are talking of? Hush puppies is a shoe. How did that particular name come about? The company had manufactured suede shoes and it was not capable of, it did not identify a name for that. It wanted to give an appropriate name. You know, giving an appropriate name is not that easy. It's not going to happen in a day or two. Companies will ponder, think, and then look at the consumer's perspective, consumer's perception, etc., and then select a particular name. In this case also, for several years, they could not find an appropriate name for that. When one of the marketing manager was going up in US, in Tennessee, he was invited by his friend for catfish dinner. While taking catfish dinner, he was also served what's called as cornmeal dough balls. The dough balls were served, food balls. And he was eating that particular thing. While eating, he just asked casually, "What is this called?" His friend says, "These are called as hush puppies." And he was very curious again. "Why do you call it hush puppies?" He said, "We have in the large fields, barking dogs. When dogs bark, to quiet the barking dogs, we give them this one, and therefore it is called as hush puppies. To hush the puppies, to quiet the puppies, we give it." You will be surprised to know this manager who was given the responsibility of finding a name jumped with joy and then said, "Hurrah, I have found the name for my product." English teachers know the idiom, right? Barking dogs, right, refers to tired, sore feet. Tired, sore feet. If for those barking dogs, if the dove balls, which are hush puppies, is the solution, then for the tired, sore feet, our shoes would be the solution. That is how hush puppies came. And hush puppies is a suggestive mark. This is inherently distinctive marks, friends. The second one is non-inherently distinctive marks. The descriptive marks, for geographical marks, or the name of a person. For example, Kirloskar, Tata, Larsen and Toubro, Rolls-Royce, or Harley Davidson, Cadbury's, right? So on and so forth. All these are surnames of individuals. But names or surnames of individuals by itself would not become trademark, but it will have to pass through certain stages where consumers will say, Tata here means this automobile. Kirloskar means this particular machine. Larsen and Toubro means an organization. Rolls-Royce means a car. So when they start relating it, it acquires a secondary meaning. Apart from the primary meaning of an individual, it becomes a secondary meaning relating it to the product. At that stage, it becomes distinctive. Though it is not inherently distinctive, it becomes distinctive over a period of time. Some of the geographical names also would not automatically become trademark, but over a period of time, it acquires the secondary meaning and relates it to the product. Like Himalaya for drugs. Monaco is a place, but you're using it for biscuits. Panama is a place, you use it for cigarettes. So, in the context of these goods, Panama becomes a trademark, whereas Panama is the name of a place. The last category, friends, is mark without any distinctiveness. where we say it's a generic mark. If you call laptop a laptop, laptop for laptop is generic and it can never become a trademark. With that background, friends, let me just tell you as to what is this particular mark that we have been talking of. And just follow this particular thing. I'll be just quick. It could be a device. It could be a brand. It could be a label. It could be ticket. Maybe a name of an individual, name of a company, name of an organization, name of a firm. Signature of an individual, popular signature of an individual. The word is the popular mark every time. A word could be an invented word, or it could be just a letter, one letter, or it could be numerals also. You can have numbers also attached to that, or it can be the shape of goods. I am sure this particular audience knows Toblerone chocolate. Toblerone chocolate is right in a particular shape, and that shape is protected under trademark. Then packaging. Most of the packaging, right, would get the trademark protection that as a trade dress. Then combination of colors. One color, many times, combination of colors also would get the protection. Combination of any of these. You can have the device and the name, device and the signature, device and the word and the letters, numerals and the letters, shape of goods and the label. All this combination could be done. They would all constitute mark. If they are capable of distinguishing, then it can become a trademark. Well then, this is another question which comes up. How about sound? Can sound become a trademark? Or it cannot? Just listen to this particular sound. Yeah. Can you make out what is this particular sound? Perhaps from the sound you will say, yeah, this is Nokia. So this sound is also registered as a trademark. If you are just going to enter into the theater and if you are sleeping and if you hear the roar of the lion, you will immediately think, yeah, this is Metro Goldwyn movie that is going to start now. So like that, sound also can become trademark. Can fragrance become trademark? Answer is yes. Sumitomo Tires, when it wanted to market its products, it had to reach out to the customers who were drivers and cleaners who went and purchased the tires. And it educated them and said that if you just go and ask for rose fragrance tires, you're going to get the Sumitomo tires, because those people were unable to pronounce Sumitomo. They smeared rose fragrance to the tires and then they started selling it. All those who wanted to purchase, they were identifying Sumitomo tire by the rose fragrance. So fragrance could become a trademark. Shape can become a trademark, as I have already pointed out. These are the examples, friends. See, the device is a device. This is a label, a ticket in the form of levies. The names, right? It could be Tata, it could be Kirloskar, it could be Rolls-Royce. Then it could be Nilgiris, also name of a particular place. Then signature, Michael Jackson's signature could become a trademark. Then the numerals, 555 gold, Hayward 5000, the numerals. Then the letters, MRF, MTR, they could become the trademarks. Well, if you are trying to select a particular mark, I would suggest that you should do a search for the existing trademark before you file an application, because it will have to satisfy the requirements. And these are some of the sites that you should go and then do an exhaustive search. Right? OHIM you can do, for Australia you can do, Europa you can do, India, USPTO, you can do the search before you identify a particular mark. And also you can do a general Google search to find out whether the name that you want to have for your organization or for your brand is already registered or not. With that background, let me just move on. This is what the Kroc who bought McDonald's was saying. If I had a brick for every time I have repeated the phrase quality, service, cleanliness, and value, I think I would probably be able to bridge the Atlantic Ocean with them. So whenever the product was being sold, he started saying quality, service, cleanliness, and value. And he says, if you take the number of times that I have said it, you could have built a bridge. And therefore, the mark here is an indication of the quality as well. What is the registration process in India? Very briefly. I know the time constraint, and therefore, I'm just going as quickly as possible. Registration process is you file an application for registration, then acceptance by advertisement by the registrar's office. There may be opposition by someone who says, I have a trademark which is conflicting with the claim made by the other individual, and then registration happens. Then rectification is possible of the registry, and in case two or more persons are using it simultaneously, they can even go for honest concurrent use of the trademark. And if you're using the names of living persons or persons who have died within 20 years, you shall obtain the permission of those living persons, or you shall also obtain the name of the permission from the legal representatives of those individuals whose name you're trying to use. Can names become trademark? I have already told you names can become trademark. Recently, Messi, our football player, won the legal battle before the European Court of Justice against Messi, another trademark, and the court said Messi also has become equally popular, and therefore the word Messi would not be confused by the consumers with the other Messi. So this is the procedure, friends, of registration of the trademark. Let me just move. When you go for registration of a trademark, there are certain marks which will not be given registration, and the reasons, the grounds on which it will not be given are two. One is absolute grounds and the other one is relative grounds. In case of absolute grounds, we will say it is not distinctive at all. It's just a common circle that you have made, if it's not distinctive. Or it could be descriptive even. You are describing the nature of that particular product. Then it could be common to trade. I'm going to give examples for all of this. It could be deceptive or it could be confusing. Or you may be using the name of a god for some unsavory goods, and it may hurt the religious feelings of the people. Or it could be a scandalous word. Or it could be an emblem which is prohibited under the Emblems Act. You can't use Ashoka Chakra. You can't use the word national. You cannot use so many words like Ramakrishna Paramahamsa Mission, so on and so forth. Or you cannot not use the international non-proprietary names, INNs, you can't use. They're all prohibited in this particular legislation. These are absolute grounds. And shape also cannot get protection under certain circumstances. For example, the Philips came out with a shape with equilateral triangle. Inside there were 3 circular rings. And ultimately, the European Court of Justice says, what is that it's going to be served by having this particular shape on which you are trying to claim the trademark protection? The answer ultimately was, this particular shape is required for an effective shaving, which means this is having a technical effect. The moment it's a technical effect or functional features, it cannot become a trademark, and therefore it was refused. Otherwise, shape can become trademarks. Well, friends, as far as descriptive marks are concerned, these are the examples that you can think of. When you are referring to the kind of product, you can't add old to the existing trademark, can't add new, can't add extra large or large and then sell it. You can also not add good or best. Those are related to quality. Quantity, for example, you can't use the word 12 with respect to wines because there are 12 bottles in one particular wine case. Intended purpose also cannot be trademarked. For example, if you say kettle clean for preparation for cleaning kettles, so that is descriptive. Twist and curl for hand implements operated for twisting action for curling hair. You can't use that. Slim and fit for slimming operations cannot be used. Similarly, value also cannot be, will be descriptive. If you say 2 for 1, worth their weight in gold, or even geographical origin also cannot be use. However, names of places with less than 5,000 population will be acceptable. You can't use names, for example, for commercial activities. Wall Street cannot be used. Dalal Street cannat be used. But if you're using them fancifully, it's possible. For example, Mount Everest if you use for bananas. Right? Names of rivers for certain products which are shoes and other things. Foreign geographical names can also be used. For example, Karachi for shoe repairs and Karachi biscuit in Hyderabad. Kansas for restaurant services may be fanciful. But Madras for masala dosa or Paris for fashion design may be doubtful. Right? Numbers and letters can also become, I have given you all the examples there. Well, friends, the next one is relative grounds on which it can be refused. There are two aspects. One is likelihood of confusion. The other one is dilution. Let me just point out quickly about this. Likelihood of confusion. Let me just give you an example of Amrut Dhara and Lakshman Dhara. There was already a medicinal product under the name Amrut Dhara, and someone wanted to register Lakshman Dhara way back in 1949. Then it was opposed by Amrut Dhara. The registrar said Lakshman Dhara and Amrut Dhara for an ordinary consumer is going to be confusing, and therefore we refuse. The Calcutta High Court, when it goes to Calcutta High Court, the Calcutta High Court judge, he says, where is the confusion? Lakshmana, he went on to Ramayana, started explaining Ramayana, and then said, Lakshmana is known for valor, and therefore this is different. Amrita, he goes back to Samudra Manthana and says, this is Amrita, and therefore there is no confusion between Amrita and Lakshmana. But there was an appeal before the Supreme Court, and the Supreme Court asks a straightforward question. And then it says, the person has gone before the shop, he has stomachache, he is asking for medicine for stomachache, and the shopkeeper says, right, this individual says, Lakshman Dhara or Amrut Dhara, DGA. And the shopkeeper says, Lakshman Dhara chalega, right? And at that particular stage, what is the position of this individual? Would he relate Amrut Dhara with Lakshman Dhara and get confused? Or do you think at that particular stage he's going to stand there and then start relating Amrita is Samudra Manthana, Lakshmana is Ramayana, and then he's going to take a decision? So the Supreme Court clearly said, you should take into consideration the stage of an unwary purchaser with average intelligence and imperfect recollection. Right? And therefore, this is still confusing. So likelihood of confusion is that. Second one, friends, is taking unfair advantage or detrimental to distinctiveness. Let me just give you an example. The Visa international card, all of us know. And there was an application filed before UK Trademark Office for trademark Visa, not for the financial services, because it was already registered and was a well-known mark. He sought registration of Visa for condoms, contraceptives. And the trademark office said, if you are using the word Visa for contraceptives, which is nothing to do with the financial institutions, it is going to damage the reputation of Visa. And Visa organization will have to keep educating its consumers that we are not connected with health hygiene. So it is going to detrimental to the reputation. That's called as dilution or tarnishment. Even under such circumstances also, trademark will not be registered. Right? If you have understood that, then these are all the deceptive marks that are there. And then let me just proceed by just giving you examples. See, Pepsi and the TAD. TAD is the duplication. Coca-Cola, right, in a different version. KFC, what is found at the bottom is KFC, but see at the top here, they just change the word, but for a person who just goes off for the first time, you would confuse it to be KFC itself. Then the real versus fake, you can make out. Most of the time, fake would be much more attractive than the real. Then Metro Goldwyn Mayer, and see here, all that they have done here is, there is a carrot in the mouth, right? And then you just go on. Nestle with nasty. Colgate, and see the triple action part there, and look at Aquafresh part. There is a result between these two, and it's deceptively similar. Starbucks versus Starbucks. And in Delhi, there was a person who came out with Satarbaksh with the same design. And Starbucks was able to prevent that. Enjoy Chicaloca. You can't make out that it's Coca-Cola or not. Aquafina with Aqua only. And Mike Wong, Adidas with Adidas. That is, friends, very briefly about the trademark protection. There are many, many issues under trademark protection, but I have just confined myself to this in view of the shortage of time. Yeah. Anything, Reshma, can you see copyright protection slide now?
Yes, sir. Yes.
Yeah. Well, friends, let me just take you through copyright, because in an educational institution, copyright protection becomes very, very important. What is protected at the copyright law will have to be understood properly. Copyright does not protect the ideas, but it protects the expressions. It protects the expressions. What is that expression that we are talking of and not the idea? Let me just give you a simple case law. R.G. Anand versus Deluxe Films. R.G. Anand comes out with a drama called as Hum Hindustani. And in Hum Hindustani, the brief facts are something like this. A Madrasi and a Punjabi family were staying together, and the children were young. But as they grew up, the Madrasi and Punjabi family, which were having a very cordial relationship, they get strained relationship because their children start loving each other. And now Madrasi person thinks that my son should not marry a Punjabi. And the Punjabi father thinks that my daughter should not marry a Madrasi. So the rift starts. And then they leave the suicide notes and run away. That is when both of them realize that the lives of children is more important. They go bring them back. Very briefly, this is the plot. At the end, it was Hum Hindustani. Deluxe Films script writer had some discussion with R.G. Anand, but did not pursue that particular discussion later. Then he goes and writes script for his movie called as New Delhi, right, in which Kishore Kumar and then Vaijayanti were there, played a key role. And the script was written, and the whole story runs something like this. A Punjabi boy comes to Delhi in search of a house, and he could not find a house anywhere in Delhi where South Indian people are located. And ultimately, he represents himself as a South Indian and then gets a house for rent. So the whole problem of housing was explained there. And then in that particular house, there was this Vaijayanti Mala. They meet at a particular dance and they fall in love. Meanwhile, the sister of this Punjabi boy comes to Delhi, and he's taken round the Delhi, and Punjabi boy introduces his sister to a Bengali boy, and they fall in love with each other. And now the Punjabi father does not want the child to marry Bengali. He's for a marriage. Here again, the movie brings in the dowry issue. Dowry issue in the marriage hall itself, and that is highlighted. After that, again they console, and the marriage of the daughter with the Bengali boy, and the marriage of the Punjabi boy with the Madrasi girl happens. This is gist of that story. Now R.G. Anand said, my copyright has been violated by the Deluxe Films because they have copied my entire work and they have reproduced that in the New Delhi. However, the court went through the similarities and dissimilarities between the two works, and it finds that what has been taken by the other, the respondent, is the idea of provincialism, that a marriage between a boy of one particular region and boy of another region is strained always, will not be promoted always. That is the theme of provincialism that has been picked up. But there are also two other themes of housing problem and the dowry problem, all three connected together. So there are three different themes on which they have built up this particular story. And so saying, the court categorically said, this is the important point that I want to highlight here, there can be no copyright in an idea, subject matter, themes, plots, or historical or legendary facts, and violation of copyright in such cases is confined to form, manner, and arrangement and expression of the idea by the author of the copyrighted work. So friends, there is no copyright in an idea. However good the idea that you might have incorporated into your work, that idea would be free for use by any others, right? And therefore, subject matter themes would not be protected unless the whole expression is, right, giving that particular impression, and the expression cannot be copied by others without deleting the theme. So in such cases, it will get. Similarly, historical facts and legendary facts. All, the entire Ramayana, Mahabharata, or Bhagat Singh, etc., all of them are legendary facts. Nobody owns facts. Facts is owned by nobody because facts fall into the public domain. Facts are not created by anyone. They happen. And therefore, facts are not owned by anyone. Copyright is not given to anyone. So this is what the court said. And the question, are there no similarities? This is what the court responds by saying, where the same idea is being developed in a different manner, it is manifest that the source being common, similarities are bound to occur. In such cases, the court should determine whether or not similarities or the fundamentals are substantial aspects of the mode of expression adopted by the copyright work. This is, friends, the beginning of our discussion that expressions are protected and not the ideas. Then what are protected under copyright law? See here, a literary work gets protection, an artistic work gets protection, dramatic work gets protection, musical work gets protection, sound recording, and cinematograph films. These are just the graphical representation of those different types of works that I have mentioned in this particular slide. Then, moving on further, what is that is covered under literary works? Yes, please. Any message for me? Hello? Krishna? Hello?
No problem, sir.
Okay. I thought there's some message for you.
Yeah, some disturbance was there. Yeah.
Okay, no problem. Literary works. See, any novel that's being written or a poem that's being written, or the books that is being written, it need not be a book of literature. When I say literary work, it does not mean it must be a book related to literature only. Any book, a computer science book is also a book, and therefore it will qualify as a literary work. And then the question paper that are being set, most of the teachers are here. This question came before the UK court, whether question papers can be literary works, whether question papers are original, etc., etc. And the court answered in the affirmative, saying that yes, they are literary works, and there is enough experience and selection which has gone into the preparation of a question paper by the teacher, and therefore question papers are entitled for copyright protection. However, the next question is answer scripts. So you can just ask the teachers here, right? Does college, is All Saints College having control over the answer scripts, and can it publish these answer scripts or not? These are the two questions that come up. First one is, you have physical possession over the answer scripts. You continue to have the physical possession because on the tangible goods you still have the right. Whereas on the copyright in the work that has been written in the form of answer scripts, then you don't have the right unless it's assigned by the student to the university. So answers written by the student, provided again, let me right, provided again that they are original. They have sufficient originality in that. In the absence of originality, answers also would not qualify for copyright protection. Fine. Abridgments are literary works. Compilations are literary works. Encyclopedia, tabular arrangements, databases, then data sheets, and anyone from computer department would know both source code as well as object code also would be considered as literary works, and that gets the copyright protection. Then the rights are associated with this particular literary work. If you have written a book, you can reproduce that particular book. I quite often ask this question, is copyright a right to copy? And people give a sarcastic smile. How can it be? But the answer is yes. If I have made a book, written a book, I have a right to make a copy of that particular book. That is right of reproduction. Nobody else can reproduce that particular work. If anyone else reproduces that, it amounts to copyright infringement. Once I make a copy, I still have the right of distribution of that particular copy. But when I distribute that particular copy, one copy, I lose the right of distribution of that copy. If I have given that particular copy to Dr. Anjana, the copy would be owned by Anjana, but she will not have copyright over the contents of that particular book. She can keep that copy. I will not have the right of further distribution of that particular copy. However, Anjana gave cinematograph and sound recording from that particular copy. She has only right over the copy to keep that copy. Right? This is popularly called as a first sale doctrine. Once they sell that particular copy, I don't have a right of distribution. I also have the right of communication of my work to the public. Nobody else can communicate the work to the public. You can't put it up on the web page, right? That amounts to violation of my right. You can't translate without my permission. You can't do the adaptation of that work without my permission. You can't include that in the sound recording or cinematograph film without my permission. Similar rights are there for the dramatic works, which includes drama, choreography, dumb show, they're all included here. Then musical work, which is a work of music where melody and harmony are included. But the best part of the musical work is the tunes are protected here and not the ancient ragas which are already in the public domain. You know, many tunes are developed based on all the ancient ragas. And do you think they are going to claim protection over the tunes as well as the ragas? The answer is no. The Madras High Court in Sulamangalam Jayalakshmi case has clearly said that you have right only over the tunes and not over the ancient ragas. You also don't have the right over the lyrics when you're claiming musical work protection. Then friends, the next is artistic work. It's a very, very vast area of sculpture, drawing, engraving, photograph. All these come under this category. Then, the sound recording and cinematograph film. Sound recording is a composite work, lyrics, music, performance, etc. Cinematography is also a composite work with many things inside it. Right, as far as sound recording and cinematograph films are, you can make a copy, you can communicate that to the public, you can sell or give it on commercial rent. That's the backdrop. Then friends, in addition to all these rights, see who becomes the author. Just imagine in your organization, you have started writing the book. Would you be the owner of that particular book? You are definitely the author of that book. You start composing, developing a code. You are the author of that particular code. Are you the owner of that particular code? You have taken photographs and you have written articles. Are you owner of that particular thing? It depends. You're always the author, but author is always the owner. But if you are a correspondent of a newspaper or a TV channel, and you are writing this article or taking a picture for the purpose of newspaper or the journal, then the proprietor of the newspaper shall be the first owner and not the author. Similarly, if a photographer comes to your institution and they take photograph of your function, the photographer is the author, but he will not own the copyright over it because you have commissioned him to take photographs. And therefore, you become the owner of that. And similarly, a person working for Infosys or IBM or any organization or an international institution or public undertakings, if he is working for that organization, then he would be an employee. And if he creates that particular work in the course of employment and a contract of service, that work becomes the work of the organization. So employer will be the first owner of that particular work. But the conditions are here. You should be working that in the course of employment. Supposing you are teaching commerce in your organization or mathematics in your organization, and in the evening or during lunchtime, you go and start writing poems because you are a great poet. Your organization cannot claim copyright over the poem that you have written because that is not done in the course of employment. Right? These are the limitations. This is about ownership. How long will you be able to enjoy the copyright? If it is literary, artistic, musical, dramatic works, which is published, entire lifetime of the author, it could be enjoyed. And after his death, his successors can enjoy it for another 60 years. So life of the author plus 60 years. But in the cases in which I am referring here, it is always 60 years. If it is an anonymous work, pseudonymous work, posthumous work, or photographs, cinematograph films, sound recording, or government work, government undertaking work, etc., etc. In all those cases, it is 60 years from the date of creation or publication. Then friends, just to give you an example of this term, all of us know that My Experiment Truth was written by Mahatma Gandhi and was first published. And after his death, 60 years have passed. Now, any one of you can just take it and then publish it. But let me just add a caveat here. Imagine now the compeer here, Ms. Reshma, that wants to publish this particular book because it's in the public domain now. Can she just publish this particular book by saying, My Experiments with Truth, remove M.K. Gandhi and put Reshma Judge? Can that be done? It cannot be done because even after the copyright lapses, even after you transfer all your rights to the publisher or to the producer of a movie, you still have two rights left with you. And those two rights, friends, are the moral rights. One is the right of authorship, and the second one is the right of integrity, called as damages that can be claimed for any modification. Just look at this particular picture that I'm showing here. The first picture, I'm sure all of you can identify Jawaharlal Nehru. When Jawaharlal Nehru wanted this Vigyan Bhavan to be built in New Delhi, he came to the building and then said, kindly don't consider this to be a place for conferences where people come and go back. It should be a place where our cultural heritage are going to be reflected. Then call the best sculptor in our country. That is where they called Amarnath Sehgal. Amarnath Sehgal comes here and then looks at the whole thing, and as per direction takes 5 years and prepares this mural that you can see there. The mural was 40 feet high and 140 feet broad. That was created over a period of 5 years. That is the first picture that you see. After 15 years, you know, the CPWD, all of us know, because PWD will not be interested in this art and culture. They were asked, they just removed them, consigned them to a go down, damaged the entire thing when they were renovating this. And Amarnath Sehgal questioned them. See, Amarnath Sehgal, the old Amarnath Sehgal in the below picture, the young Amarnath Sehgal on the side standing there. And the court here said, you have destroyed this particular thing, and that by destruction, you have taken away the corpus itself. So it is mutilation of the entire corpus. And that is violation of the right of integrity of the author. And therefore, author should be paid a compensation of 5 lakh rupees. So that takes us, friends, to the issue that even after you transfer all your rights, your right of authorship still remains with you. You can question any modification done to your work, which is going to affect your honor and reputation. That is the moral right that is still continuing to the individual. How can you exploit this particular copyright, and when can you sue another person for infringement? These are the two questions that come up. You can grant license for your copyright, different licenses for different rights that you have. You can also assign all the rights to others, or assign each one of those rights to different persons. Maybe you can call a director and then say, you get a right for making a movie. You can call the publisher and say, you get the right of publication of so many copies. You can call a translator and then say, you can translate this particular work into Malayalam, Tamil, and Kannada. All rights will be assigned separately, licensed separately. That is the right that you are going to get. And when then there's an infringement is you have all the rights with you, and those rights are exercised by others. And if those rights of reproduction, etc., are exercised by others, it amounts to violation of your right, it amounts to infringement. Right? And similarly, if a platform is provided for putting up infringing materials, that would also amount to violation of your rights. Like this is the major problem that is happening now. Can you put up infringing copyrighted videos on YouTube? And if you put up on YouTube, what is the consequence? Can the copyright owner ask the YouTube owner to, right, take down that particular material from the website? These are all relating to secondary liability and also infringement of the copyright. Well, friends, just have a quick look at this particular thing. This is Washington Cathedral in Washington, D.C. You can see here the work done. This particular work is a very unique work created by Mr. Hart. And when he created that particular work, in the movie 12 Monkeys, Devil's Advocate, in the movie Devil's Advocate, this particular replica was created. And if you have seen the movie, anyone who has seen the movie Devil's Advocate, you will find that when the conversation goes on, you can see these particular characters. All these characters will come to life and breathe erotically. That is how it has been presented. And then Hart and the Washington Cathedral proceed against the producer of Devil's Advocate, and they say that you have violated our right by reproducing our work, which is our right. So it is violation of our copyright. Second one, by creating this particular situation of those characters breathing erotically, you have violated our integrity right, that's moral rights. And the respondent accepted, acknowledged, and entered into a settlement. Settlement, they said, this is the disclaimer that they made, saying that the large white sculpture of human forms on the wall of John Milton's penthouse in Devil's Advocate is not connected in any way and was not endorsed by the sculptor Frederick Hart of the Washington Cathedral. And after that, it was cut down to some 10 minutes, and then it was permitted to be released. That's it, friends. And then let me just move on. There are remedies also in the form of injunction damages, account for profit. There are also criminal remedies. You can file a complaint, and then the person can be imprisoned if he is violating the copyright. Then, another example I just like to give you. What you see here is a work, an artistic work written by a person by name Lebes Wood. This is in the form of an interrogation room. If you can just watch here, this is the chair, and this is the railing on the wall. And this is the light that's going to be projected on, beam of light projected on the person who is going to sit here. This will be down, and the person will be asked to sit on this particular chair, and it will be pulled up. When it's pulled up, he will be hanging in between, and from where he will be questioned. So this interrogation room was imagined and then written by Lebes Woods. The producer of 12 Monkeys, in his movie, wanted to have an interrogation room of similar kind. And he acknowledged that he had seen this particular thing and he was influenced by this. He takes up this one and then creates a room. Just see here. This is the room that he created in 3 dimensions. And similar structure, the light here, the chair that moves up and hangs up, and the person to be interrogated is hanging here, and from there he'll be interrogated. So in the movie, they show some 3-4 times this particular room. And Lebes Woods had objection to this. He said, you have violated my right. So in case of artistic work, this is an artistic work. In case of artistic work, conversion of a reproduction of 2 dimension into 3 dimension, or 3 dimension into 2 dimension is infringement of the copyright. For example, if a statue is made by you and someone takes photograph, or if someone has written a drawing and you make a sculpture out of that, both are violation of the copyright. Then, friends, but let teachers and academic people know the last part of the whole thing. That is, when you copy or reproduce a particular work, don't be under the impression that always you are violating the copyright of some other person. But it can be fair use or fair dealing as well. See the circumstances under which your act will not amount to infringement. For example, if it is for research purpose, for private study, and for criticism or review. Plus, there again, be very careful. If you copy the entire work and at the end add 2 sentences by saying that I do not agree with any of the opinion given by this particular author in this article, it's not a review. should be a review for which you're going to refer to that article in bits and pieces. It should be criticism of that, a reproduction of that. Similarly, if you're reporting current events, you can pick from any copyrighted work and then report current events. If someone dies now, an author, a popular actor dies, you are going to bring in all the movies that in which he has played. That may be violation of the copyright of the producer, but you are reporting the current events and therefore you are presenting his biography. And for education purpose, see, in the course of education, the Delhi photocopying case, the Delhi High Court said that anything that is created in the form of course pack in the course of instruction would not amount to copyright infringement. Then performance by an amateur club. Next is reproduction for use in the libraries, reproduction for use in the legislature or judiciary, reproduction of any government work, and incidental inclusion artistic work. You are taking a movie and you come across a copyrighted material in the museum and it's captured, but it's incidental. Similarly, reconstruction of building in accordance with architectural theme, or ephemeral recording, or if it is for a computer purpose, computer program, you take a backup copy, right? And the most important one with which I would stop for a while is that making copies in accessible format for use by the person with disability. This change, friends, we brought about after 2012 amendment. And the Marrakesh Treaty also has come into existence, which provides for this. A blind person will not be able to access a copy in the library. And has the university made it print disabled friendly? How would it make it print disabled friendly? It will have to convert that into accessible format, maybe audio format or braille format or so on and so forth. Is that conversion reproduction? Yes, it's reproduction. Is reproduction the right of the copyright owner? Yes. Is reproduction without his permission amount to infringement? Yes. But this is a case where exceptions are created by the Copyright Act itself. And therefore, if it is done for the purpose of facilitating the person with disability to read that particular book, such making of copies is registration is possible in case of copyright. And that is very briefly, friends. I think, and I am conscious of the timings, and therefore I have just touched upon a few aspects of trademark law and copyright law. Thank you very much. I'll stop here. Reshma? Yes, I'm just looking at the time, and let me not trespass into the others' timings. I know my good friend Ajit Prabhu and Lisa both are waiting here.
Is there any questions? Or
Yes, please.
clarifications?
I don't mind taking this. Can the participant unmute and then speak instead of writing on the chat?
It's in the chat box posted here.
Yeah, please.
There is a question from Dr. Sonia J. Nair. She is
Yeah.
asking why don't the companies like Xerox consider the fact that their product names becoming generic is actually free advertising?
Yeah. Free. When the trademark becomes generic, there is a threat of losing the trademark status. And with respect to such products, anyone can start using the word Xerox. So that's the danger that is there. As I told you, aspirin was declared to be generic by the Supreme Court of US when everyone started using the word aspirin for these things. And that danger is there, and you will have to guard yourself against such danger. Yeah, next question.
Dr. P.S. Anjana is asking can we redraw the figures in a manuscript instead of getting copyright from the publishers? Can we redraw the figures in a manuscript instead of getting copyright from the publishers?
You're referring to a different situation. You're not clear. If I have understood you properly, there is a book published by you in which there are drawings. Am I right? Ms. Anjana?
Yes, sir. Yes, sir. Yes, sir.
And now you want to write a separate book, right?
Yeah.
In which you want to utilize the same drawings, right?
Yes, sir.
That's what you're referring to.
Sir, but we can withdraw the figure without getting the copyright of the publisher.
No. You are referring to two different situations. If you have the freedom to write your book and then draw the pictures on your own, right, there is no question of copyright of the publisher. But the question of copyright of the publisher comes when you have already published it and already assigned all your rights to the publisher. Especially the teachers here should be very careful when they sign the assignment deed with the publishers. They should retain certain rights with them. Right? And transfer rights to the
You are breaking in between, sir. You are breaking in between.
You're saying that you're trying to. Hello?
It's not clear, sir. Your sound breaks.
Yeah. And now it's clear?
And now it's clear, sir.
Yeah. Anjana, this is the point that I was trying to make. There are two situations that you contemplated. One is you have already written a book in which the drawings are there, which has been published already, right?
Yes, sir.
And you're writing a second book in which you want to pick up the same drawings and then make use of that. Right?
Yes, sir.
Am I right?
Yeah.
And now we are trying to say that without seeking the permission of the publisher, can I redraw that? Is what you're trying to say.
Yes, sir.
There's a difference here. This is a case of infringement. See, when you're trying to redraw that particular thing, is it substantially similar to what you have already transferred to the publisher? If not, then you're free to create your own drawing and then proceed. On the other hand, if the copyright is transferred to him and therefore you need the permission of the person.
Okay, thank you, sir.
Yeah. Any other question, ma'am?
There is one more question from Dr. Sonia Jenayar.
Yes,
The
ma'am.
question is, can an author's story for which he has given permission to one person to publish be published or electronically recorded by others if the author consents? That is the first part of the question. When
Please repeat it, madam. Please
Can
repeat it.
an author's story for which he has given permission to one person to publish be published or electronically recorded by others if the author consents?
Okay.
When publishers write no part be reproduced without permission of the publisher, what if we have permission of the author? Can we publish it then?
Yeah. See here, I was telling you about authorship and ownership very clearly. The rights that are there in section 14 is conferred on the owner and not the author. Author's rights are there in section 57 of the copyright in the form of moral rights. If the author has given permission to X for the purpose of publication of a particular work, right? And if he has assigned that particular right to the publisher, that's very important here. If there's merely a license granted to another individual to make use of his work, then he still has a right to grant permission to others. If he has already assigned that, see, there's a difference between licensing and assignment. Have I granted license? If I have granted license, is it an exclusive license? If it's an exclusive license, I cannot give license to any other person. Right? Then, have I assigned that particular thing? Is it an absolute assignment? If I assign, then I cannot assign it to any other person. If I have given license merely for publication by an individual, nothing prevents me from giving permission to any other person for utilizing that particular work. So you'll have to draw a distinction between licensing, assignment, both these. And you'll also have to draw a distinction between ownership and authorship. The author has become the owner, first owner. Has the author transferred the ownership to some other person? If you transfer the ownership to some other person, then over that particular work, the second person is the owner. And you need the owner's permission for publishing it because author has already relinquished all his rights. So that is how we'll have to look at the whole scenario. I no more remain the owner. When I no more remain the owner, you'll have to contact the owner. It's something like I have a house and I have sold the house to Miss Anjana. Now, can you buy that particular house with my permission? Why am I to give permission? Because I am no more the owner of that particular house. So that is how the whole scenario works. Hey, anything else, madam?
No further questions, sir.
Yeah. Okay.
Yeah, I think now we can wind up the session and to conclude. And there is vote of thanks.
May I now request Dr. Sonia Jenayar, Head, Department of English, to propose the vote of thanks.
Thank you, Sini. That was a wonderful introduction to the intricacies of copyright and trademarks protection in India. And Professor Ramakrishnan has beautifully brought out the complexities and nuances of branding and trademarks and copyrights and so on. And as well as, your engaging styles, the way you incorporated films and advertisements and anecdotes into your address, you actually made this topic come alive in a very brilliant fashion. And then, you took us across the world, America and everywhere, and then came home right to us in an education institution. And now, we're very happy to know that we have rights over our question papers, but thankfully not over the rights of the answers of the students, provided they are original. So, and thank you for answering our questions and clearing our doubts. We would like the audience to thank the audience also for their participation in this very, very engaging and riveting session. Thank you very much.
Thank you so much.
Thank you, Sonia. May I now request Dr. Sunita Kurur, Head, Department of Chemistry and IQAC member, to welcome and introduce the speaker of the session. Not audible.
Am I audible now?
Yes.
Okay, thank you. Good morning all. So respected Principal Dr. Deepa M, the Member Secretary of Higher Education Dr. Rajan Varghese, the distinguished resource persons of the webinar, all the faculty members, the participants. We have come to the second session of the webinar after an excellent and informative session by Dr. T. Ramakrishnan sir. It gives me a great privilege to welcome Dr. Ajit Prabhu, the second resource person, to this session. He holds position as Chief Scientist, Scientist G, in the Kerala State Council for Science, Technology and Environment, and also the Nodal Officer of the Intellectual Property Rights Information Center, Kerala. Let me give a brief introduction about him. About sir, regarding his qualifications, he is BTech in Mechanical Engineering, MTech in Thermal Engineering, MBA, PhD, and also PG Diploma in Management, PG Diploma in Intellectual Property Rights, Disaster Management, Environmental Sciences, Rural Development. He has held a position as scientist in the Liquid Propulsion Systems Center under ISRO for 10 years, Energy Technologies, and head in R&D in Energy Management Center, Director of Center for Science and Technology Entrepreneurship Development. He has authored 2 books in Malayalam, one in IPR, Bauddhika Swathum Avakashangalam, and the other one on lightings and lamps, Velichavum Vilakkugalam, and co-authored 4 books on environment and biodiversity. He is recipient of Children's Science Literature Award 2018, instituted by Kerala State Institute of Children's Literature, Government of Kerala. He has delivered a number of expert lectures in the related subjects and published several papers. He is fellow in Institution of Engineering and member in various professional bodies. His area of interest is research and innovation in engineering and technology, entrepreneurship development, IP management, science popularization. We are grateful to have Dr. Ajit Prabhu sir to this session. He will be talking to us about intellectual property rights, why, what, and how. Let me formally welcome Dr. Ajit Prabhu sir on behalf of IQAC All Saints College and on behalf of all the participants. Now also, I apologize for the delay on our part on behalf of IQAC. And once again, welcome you, sir, to this session. Over to you, sir.
Thank you. Good morning to all. Special regards, love and regards to Professor Ramakrishna, a stalwart in this field, and he is always a good friend of KSCST as well as he is a mentor of KSCST for all our IPR related activities. Thank you, sir, for your enlightening lecture also on trademark as well as copyright. And I am especially thankful to you because you have reduced my effort in explaining these 2 aspects. At least, no, with this I can explain only the other IP forms only. So thank you so much. And also you have elucidated it with a lot of examples and all. Excellent talk. And I'm so happy to associate with this national webinar organized by All Saints College. And I really appreciate the management for organizing such a workshop, especially in a relevant, very, very relevant field, and also in the adverse, climate like the epidemic and other things. So that deserves due appreciation. So I think I have time till 12 o'clock. I have prepared few slides for 45 minutes. I will try to compress it. So please bear with me to switch over to my presentation mode. 1 second. Yeah, is this visible? My slides are visible.
Yes, sir.
Am I audible?
Yes, sir. Yes, sir.
Okay, madam. Thank you. So I will be giving an overview about the intellectual property rights. What is that? Why intellectual property rights and how it is done and all. Probably these things might have covered because I joined late in the session by Professor Ramakrishna. Intellectual property rights refers to the creations of mind, which of course can be understood by inventions, literary and artistic works, symbols, names, images, and designs. So anything that is created by mind. So that is why IP is always linked with innovations, inventions, ideas, creativity, etc., etc. So IP refers to the creations of whatever new your mind creates. That is referred to as intellectual property. And intellectual property right means legally enforceable exclusive right granted to the owner of the intellectual property for a limited period. For a particular period of time, the inventor or the owner of the IP is getting a legal right, and that is an exclusive right over the creativity or the IP of the mind. What are the purpose of granting IPR? Of course, this century is known as knowledge century, where knowledge is very, very important, and knowledge is the source of wealth. So that is why even the startups, entrepreneurship, everything is linked with innovations. All the startups, major startup and entrepreneurship, if you see, that is based on innovation, innovation-based startups or innovation-based entrepreneurship. So so immense wealth is there in the creativity or IP. What will happen if you do not protect that? In simple words, somebody else will take away the benefit of that. There is no point in weeping further, say, oh, I only have invented that, but now somebody else is reaping the benefit, etc., etc. It is something like, I will go to the, I will explain that. See, it is something like, you have paid money for purchasing land near your house or wherever. And suppose you are not registering it in your name. You have paid the money, that is true. But legally, you are not the owner. So what will happen? Somebody else will use that property. So, of course, that property means we can visibly see, because that is a tangible property, whether it is movable or immovable property, etc. Similarly, there is something called intangible property. All the IPs comes under intangible property. So, that has to be protected to reap the benefits or fruits of the inventions or creations. So, in simple words, the purpose of granting IPR are to give official recognition to the creators. That gives recognition. Yes, you have created. For example, you are, say, in the science or engineering field or biotechnology related field, you have invented something. Maybe some small thing, some machine or something, or some drug or something, that gives recognition to you. You have a patent. You are a good researcher. You have so much number of patents in your credit. And always know, in the academic forum, especially where faculty as well as students are participating, I inspire them by saying that, suppose you have patent, you become one among the elite class of scientists who hold patents. So that is something, a big recognition. Now, our academic system, UGC and other systems, now started recognizing the importance of patents and other IPRs, and that also gives you so much recognition. Now, recently, probably you might have seen, it is published world over, the scientists, 2% who belongs to 2% of the world scientists, top scientists. If you look at their profile, you can see they have large number of patents in their credit, huge number of publications, etc., etc. So that gives official recognition to the creators, and that provides incentive towards creative. Suppose somebody is inventing something. What is the incentive for them? Why should I invent? What is the benefit to me? There should be benefit. So IPR system provides an incentive system. That is why it is called exclusive right. Also, it facilitates industrial growth in a country. Industry can prosper only when new products, new technologies are invented and coming in the market. Also, it promotes R&D, research and development, and encourage investors in R&D. See, that is again another reason why it should be protected by taking patents and all. Patents gives exclusive right, or rather you can say in marketing language, monopoly rights, so that anybody can invest fruitfully with the belief that yes, nobody else will come with the ownership of these inventions, and I have monopoly market in the global or other market. So that gives an encouragement to the investors. Suppose there is no patent or something, investor may not be confident that somebody else will come or not. That kind of things are there. So it encourages investors. So IPR system protects the interests of manufacturers as well as marketers. I already told the monopoly marketing situation, and to prevent the piracy of original works. Of course, Professor Ramakrishna in his enlightening speech, he has explained with examples, so I don't explain that. Also to provide protection for our culture, traditional knowledge, and folklore. We are familiar with a lot of traditional knowledge in medicine, Ayurveda and other systems, medicinal plants, folklores and cultural practices, etc., etc. That has to be. So these are the purpose of granting IPR. As per TRIPS agreement, IPR refers to 7 forms: patents, copyrights, trademarks, industrial designs, layout designs of integrated circuits, geographical indications, and trade secrets. These are the 7 forms of intellectual property rights as per TRIPS agreement. I will be explaining one by one briefly because of the time constraints. I have got 15 minutes more. So I will explain it with this diagram. See, patents refers to inventions, in fact. I told you, invent something. Okay, it need not be a big thing. I will, of course, try to give some examples also. You invent something new. That should be a technology, that should be a product. That you can protect by taking patents, filing patents. Then, of course, literary and artistic creations, copyright. Needless to explain that, already you have listened to that. Similarly, trademark also, whether brands, symbols, etc., etc. Industrial design, any product you take, whether it is automobile, whether it is a bike, whether it is a phone, whether anything, watch or anything, it has got a physical shape. That you can, that configuration, that physical shape and size, you can protect by taking industrial design. Then geographical indicators, there are certain products like Kanjipuram silk, Darjeeling tea, etc., etc., which I will explain that later. So that comes under broad classification of IPR, geographical indication. Then there are integrated circuit layouts. Computer professionals, IT professionals, electronics people are much familiar with IC layout. With that IC layout only, a system can work. So that semiconductor, that layout can be registered under semiconductor design and layout. So then trade secret, I will give a glimpse to that at the end. So if you, with an example of a phone, you see that. See, here you can see patents. So data processing method, operating system, maybe the touch screen technology or the audio video modulation system, operation of camera. And a phone consists of several technologies and patents. It is not a single patent. Small things, of course, that enable some operation, that comes under patents. Then trademarks. You have Nokia, Samsung, or any other iPhone or any Apple phone or any other, that is trademarks. Then you look at design, physical shape or size, that can be registered as designs. Then copyrights, of course, the software used for so many functions in that, and ringtones, user manual, so many things, you can again register copyrights. Then trade secret, suppose something you want to keep it as secret, which you don't want to reveal to other marketers or manufacturers, you can keep it as trade secret. So this gives an overview of what is what with an example. So coming to the first IPR or IP, what is patent? It is a right awarded by the central government to an individual or group of individuals for exclusive rights on their inventions and disallowing others to use, practice, sell, or market that invention without their consent or permission. That is the most important and interesting part in a patent. Once a patent is granted, you are the sole owner. Like that immovable property I told, you have a piece of land here that is registered in your name and you are the owner. So you can do anything with that property. But without your knowledge, without your consent, nobody can even enter your property. So that much strong system, legal system is there for patents also. Similar kind of boundaries and other things are well specified and defined, even though it is an intangible property. That is a technical part. I will, of course, if time permits, I will go to that, or maybe in some other session, I will handle that. So right is intangible in nature. It is not like a building or a motor vehicle which can be seen, felt, or etc. So what is a patent? A patent is granted for an invention. Whether it will be granted for all inventions? No, only for new inventions. Something new you are inventing. That is why innovation. Innovation is, of course, having marketable applications. That is why, that is the slight difference between innovation and invention. Of course, most of you are aware of them. So it is given for a new product or process. Only for products, technological products, technologies, process, etc., etc. And there are only 3 conditions. That is the most interesting part. Novelty, non-obviousness, and industrial application. Novelty means newness. How far it is new? Whether somebody else have already filed a patent on that, whether it is already published or nothing, but you are first creating it in the whole earth. If it is so, that has novelty. If it is already published, that is why we always advise in this academic forum, suppose you do something in the lab which you feel that something new you are going to do, definitely any research leads to something new. I believe in that strongly. But before publishing, please make a second thought whether I should publish it or I will file it first, file patent first and then publish. We are getting lot of queries in our patent information center. Sir, I have already published. Now somebody is advising us to take patent, but how I can do that, etc. And even in the patent search form, while the patent is, of course, to check the novelty, you have to undergo a process called prior art database search, or in simple words, patent search. While doing patent search, my own publication has been cited. So, which comes against me. I was thinking that I am the owner of the publication. I have only invented that in my lab. But now when I go to file it from the IP office, patent office, they say that it has already lost novelty, so you cannot file a patent, citing my own paper. So that is actually an eye-opener for all the researchers. So if you have a feeling that you are finding or researching something new, please make an attempt to file patent first and then go for publishing. So novelty is the fundamental subject matter of patent. Then non-obviousness. Non-obviousness means there should be an inventive step. That means it should not be known to a person skilled in the art. Always I give a very simple example to understand this concept. Suppose a chair, of course, you know a chair has got 4 legs. Suppose somebody comes and say if it has got 5 legs or 6 legs, it will give more strength and that kind of added advantages that will take away your backache and many things advantages can say. So on a prima facie it may feel that, oh, it is a new thing. But no, because even a carpenter who is semi-skilled even, or an engineer skilled, he knows number of legs, and there is a trade-off between number of legs and its function. That is why it is reduced to either 3 or even 4, not more than that. So that loses, that is obvious. There is no non-obviousness. That means that invention is obvious. It is not under non-obviousness. So novelty, non-obviousness, then industrial application. It must have an application, your invention, whether it is a process or product. I believe that always know whatever you invent, it will have today or tomorrow a lot of industrial application. Okay, so these are the 3 subject matter for patents. So patent is, so right side you see this is a patent certificate. It is issued from Government of India in the patent office. You can see the IP emblem, Government of India emblem, and all the details will be your patent number, application number, date of filing, who is the patentee, etc., etc., what is the invention, etc. With this, it is something like you have registered, you have that registered document with you for that piece of land. Same thing for patent also. Now, with this certificate, it is clear that you are the owner. So you get all the legal rights reserved for you. Tomorrow, somebody is duplicating it, somebody is marketing it or making it without your knowledge. You have got all rights to enforce the legal rights accrued over you. Go for filing cases and other things. I will explain later. And a patent is valid for 20 years. As per the TRIPS agreement, it is for 20 years from the date of filing. After that, it goes to the public domain. Then anybody can use it or market it or manufacture it. So a patent allows you to sell the invention. You can sell it to somebody or license it. You can license that invention to somebody or even assign it to somebody. So many things are there as the advantage. So these are the rights of a patent, the rights to exploit the patent. That means exploit means you can make it, you can market it, you can assign to somebody, anything. Right to assign and license the patent. Of course, Professor Ramakrishna was referring to this. You can assign to somebody, fully you can assign to somebody. Or you can license. That also there are several conditions. Full licensing is there, part licensing is there, exclusive licensing, etc., etc. Then right to surrender the patent. Suppose you feel now it is that kind of life-saving drug or something that you have invented. You don't want the monetary benefit of that. Then you can surrender the patent. Then government will be the owner of that. Then right to sue for infringement. Suppose somebody is infringing your invention, you can always have got 100% right to sue for that. Then, of course, if you ask me what are the categories or types of patents, there are 3 types. Of course, there is no types or anything, but product patents, that means for patents and process, whether it is a biotechnology process or pharma process or a chemical process, that process you can patent. And together, product by process also you can patent. And Indian patent system is governed by the Indian Patent Act 1970, which has been amended later. So there is something like called provisional specification. Of course, earlier I was referring to one example. Somebody has published it and lost patenting scope. So what you can do? Suppose you are doing something in the lab, then you can file a provisional specification. It is a very, very simple thing. Maybe the fees is maybe 1,500 rupees you have to pay. I will explain it at the end of this presentation. Then it is patent office will not do anything on that, but you get the priority. And nobody can tomorrow say that I have only invented it, not that professor. You have done it. So you get that authority also. So that prevent others to claim your invention. Then you need to file the complete specification in 12 months of time. I always give an example of a safety pin. You know, a safety pin is such a simple, or you can say simplest product or invention. But you know, that has got a patent. Why I'm so showing this means many a times, of course, now that myth has been slowly coming down, but earlier when we started this patent information activities, wherever we present like this, people have a feeling that, oh, patent is only for scientists like Einstein and Edison and all. Who are we? No. So even a small invention, that is why I show the example of a safety pin. It has got a patent. That means you need not invent something very, very big like nuclear engineering or space related engineering, or the one small thing. It should have three subject matter: novelty, non-obviousness, industrial application. These are the only three criteria. So this is patent for bicycle. Then this is again another patent for insulin production method, that is for a process patent. Then another example, with this I am stopping this patent aspect. See, one inventor has invented, you know, his name is Ermel Fries, you know, this Coke can. It's a very interesting thing. Why I'm saying this, you know, even though it is a small invention, you know, he is getting huge amount of royalty. It is somewhat like 148,000 UK pounds a day, close to 2 crores a day. You know how much wealth is involved in an invention. This example is explainable for the kind of wealth involved in an invention. So he is getting royalty every day. Then next one, copyright. I am just skipping it because that doesn't need any further clarification. Of course, Professor Ramakrishna, the stalwart, the top man in the country to explain, he has already explained that, so I am leaving it. Then trademark, that also I am leaving it with your permission. Then comes industrial designs. Already I told you, you look at the shape of a chair or a seat or any device, it has got a physical shape. Different bikes, different scooters, probably the engine and the technology may be same, but the difference is in the look, maybe the shape you can see, maybe the color, maybe the slight change of shape and all. This you can register by industrial designs. Okay, so that is the fourth IPR. First one is patent, then copyright, trademark, and now industrial designs. Of course, being All Saints College, I know most of women and girls are studying there. Designs. You will be interested in gold designs, and you go to the jewelry, whether it is Bima Jewelry, Chemanur, or whatever it may be. How you are purchasing gold? Is it just like you purchase maybe rice or something, you say 10 gram or 1 kilo rice, like that you say 10 gram gold, 100 gram gold? No, absolutely no. You are looking at the design and you get fascinated. But actually you are paying for the gold, but you are purchasing it by virtue of the design. You see how important the design is? So that is the value or marketable value associated with a design. So an industrial design is that aspect of a useful article which is ornamental or aesthetic. It can be two-dimensional, it can be like patterns, lines, colors, anything, or three-dimensional, anything. Only thing, it should be aesthetic to the eye. It must not have any functionality or anything. A design must be new or original and industrially reproducible. So that is the only one condition. It should be new and it should be original. It should not be copy of any design which is existing. It should be new, your own design. And it is very simple and easy to get. Also within 6 months you can get a design registered. So yeah, these are the governing acts. You can see here Design Act 1911 repealed in 2000-2008. Then comes the fifth one, geographical indications. Already I told you, you can see a lot of products here. Aranmula Kannadi, our own Kerala's product. Then Darjeeling tea, Kanjipuram silk, and many things. French champagne and many things. GI is a sign used on products that have a specific geographical origin. It is always linked with the place of origin, from where it comes. Okay, so these are the three attributes: uniqueness, quality, and reputation. That should be unique from that place. In Kerala also we have got nearly 26 GIs like Nyavara rice, Palakkad and Matta, Malabar pepper, spices like Alapi green cardamom, Vadakulam pineapple, Wayanad Jeeragashala, Gandhagashala, Balarampuram sarees, and so many things. So it has got some uniqueness. For example, Balarampuram saree, that has got some uniqueness in its fabric, in its nice kind of form, and many things. Similarly, the rice also, Nyavara rice, that has got a lot of speciality, uniqueness, and that comes from a particular place. Palakkad and Matta, it comes from a particular region. So it is associated with a particular place of origin. That is why it is called GI. Then sixth one is integrated circuits layout, IC layout. Already I told you, in computers, in other electronic devices, that is made use of, and layout of transistors and other circuit elements, including lead wires connecting such elements and all those things. So that also you can register. Then trade secret, already I explained. So something you can keep it as a secret with you. If you file it, it may become a patent, but if you file a patent, you can enjoy the fruits of that IPR for 20 years only. But if you are so confident that you can keep it as a secret, like Coca-Cola, which has crossed 150 years, they are still making money out of that secret formula of that Coke, and they make a lot of money. So that is called trade secret. There is no formal registration or anything. I'm coming to the almost last couple of slides. Multiple protection is also possible. Okay, so don't think that, no, suppose you have an invention, you invent something, only one patent only it is qualifies. No, I'm giving an example of a treadmill. All of you know treadmill. So you are inventing a treadmill. So in that, a new drive mechanism you are designing. So you can go for a patent. Then it's engineering drawings and all. It, of course, definitely copyright. And there is a software program which controls the operation of the treadmill. You can go for copyright. Then external shape, how does it look like? It's the height, it's a physical 3-dimensional, 2-dimensional shape and size, etc. Qualifies for design. Then you give it a name, like a brand name or service name. You can register it under trademark or service mark. Then suppose in that machine you use some certain IC chips. So IC machine, IC layout protection is possible. Suppose you have certain special algorithm which only your machine has got. You can keep it either as a trade secret or copyright or even patent. So all these things are possible. So your invention is primarily a treadmill, but you see how many IPRs you can register and get advantage of that. Now, how to do this and where to do this? So there are mandated Government of India offices. Okay, so for example, Patent Office. If you see, there are 4 offices in Kolkata, Delhi, Chennai, and Mumbai. For South India, for all of us, you have to file patent in the Chennai IP office. Okay. Similarly, designs, of course, in Kolkata, but in Chennai also you can register it. They will accept it. Then trademarks in Mumbai, Delhi, Kolkata, Chennai, and Ahmedabad. Similarly, geographical indications in Chennai. Then, of course, the other forms I have not told that there is a plant variety protection and biodiversity authority. Their gene banks and other things are there. So that is in Delhi. Registrar of Copyrights Delhi, but now you can register it in Chennai office also. Then filing procedure. See, this is the filing procedure. You are filing a patent application. As I have told you, either you can submit a provisional specification, but before 12 months, you have to file the complete specification. So that is called filing of patent application. Then only it will start, procedures, undergo procedures. Then usually publication will be publicized in the Gazette after 18 months, but there is a provision for early publication. You can file a fee for that. And pre-grant representation by any person, that means anybody wants to oppose that. Suppose somebody says that, yeah, this is similar or this is a copy of my invention, they have the right. Then you have to do request for examination after publishing. Then, of course, that fees and other things you can pay initially itself. Then examination will be done. What is the examination? As I have already told, they are checking 3 aspects: novelty, non-obviousness, and industrial application. Then publication of grant of patent, and then post grant opposition. Even after granting the patent, there is a provision for opposing that. Of course, the famous turmeric case as well as neem case, who filed patent in US as well as in Europe respectively, that has been actually opposed by government of India, and that has been cancelled and repealed subsequently. So post grant opposition, but within 1 year you have to do. Now there are a lot of concessions for startups, especially women women startups, etc. So I don't go into the details because of the time constraints. So first, your application form, you have to fill it in form number 1 with a fees of 1,600 rupees for individual. If it is an institution, almost 4 times that fees comes. I am not giving the details now. So you can file online also. Then form number 2, that is complete specification. So this one is a provisional specification. This is complete specification. And each sheet, in addition to 30 sheets, 160 rupees. Each claim means, as I have told you, the physical boundary of immovable property. This is called claim, which gives the boundary of invention. Then form number 9 for early publication, 2,500 rupees fees you have to pay. Then form number 18A for expedited exam. If you want to expedite the examination, you can do that. For startups, so with all these things, with 6 months to 1 year, you will get a patent. But that is the special corridor now government of India has sanctioned. So this is the fees and this is the procedure for filing patents. And with almost last slide, I'm stopping. We have IPRIC here, Intellectual Property Right Information Center, Kerala. It is instituted through a government order. This is the GO number. And we are providing services on all forms of IPR, including patents, copyrights, trademarks, etc., and industrial designs, geographical indications, traditional knowledge, etc. And IPRIC acts as an advisory body to the government of Kerala on IPR matters, drafts the policies or rules on IPR related matters for the governments. All departments and organizations or institutions or enterprises in the state can approach IPRIC for IPR related matters. And the kind of services provided are technical and legal support services for filing patents, copyrights, trademarks, industrial designs, geographical indications, then traditional knowledge, etc., through the official attorney. In-house prior art patents that we are doing absolutely free of cost, and guidance to innovators or creators for protecting their IPs, access to IPR related documents, and help desk for clearing doubts on IP related matters, etc. And some schemes are there in which we are providing technical and legal assistance for filing IPs through KSCST official patent attorney. Then suppose somebody wants to propose some seminars or workshops, and we are providing financial support also for that, and all kind of legal technical support. With this slide, I am coming to the end of my session. Major achievements, we have organized 434 IPR awareness programs, including 15 webinars, excluding today's this webinar. Then processed 1,003 patent facilitation applications for filing patents, and facilitated the filing of 70 patents and 8 patents already granted. And we have established IPR cells in 8 universities, 14 colleges, science as well as engineering colleges, and 1 in district industry center Trivandrum. And we have brought out IPR policy. We are publishing a biannual journal of traditional knowledge and folklore practices. We are publishing quarterly IPR bulletin and pamphlets and leafletter, etc. So for any queries on IPR, you can count on us. You may contact us, Intellectual Property Rights Information Center, Kerala. It is situated at Pattam in Shastra Bhavan, where KSCST headquarters is situated. This is the phone number, and this is the email ID as well as the website. And thank you for giving me an opportunity to associate with this national webinar on IPR, and special thanks to the management of All Saints College for organizing this workshop. Thank you so much.
Thank you, sir. Sir, one question from the audience.
Yeah.
So what's the punishment for infringement?
Yeah. That depends on the intensity and gravity of infringement. It can generally go up to 2.5 lakh rupees punishment and 2 years of punishment. But depending upon gravity, if you look at certain cases like Apple case, the Samsung cases, the punishment in the sense of this thing they have to give in terms of billions of dollars and millions of dollars. So you cannot say that in this particular that always any case or anything depends on the intensity, how much you have stolen or infringed, whether you have infringed in full, infringed in part, etc., etc. So that is a legal aspect in fact.
Okay. Any more questions? Sir, then the same participant asked the question, is it arbitrary then?
Arbitrary means?
Sonia, can you explain?
Yeah. Question is not clear to me.
Yeah, I want to know if the the penalty is on the basis of let's say the conscience of the judge, or do they kind of establish how serious the crime is, on what grounds? That's what I was wondering.
How serious that infringement is based on the intensity of infringement.
So that would be subjective upon the adjudicator?
Yeah, definitely. Because, already, of course, I have a few slides of the cases also, but because of time constraint, I am not able to present that. If you look at certain cases, for example, Samsung has in one place infringed some small technology of Apple iPhone. So iPhone claims that they are making a huge profit or benefit out of this infringement, and this is patented by me or by our Apple. So that is worth this much of rupees. So the judge actually makes actual judgment of what is the compensation to be given for the infringement. If it is proved, it has to be proved. Of course, any case it has to be proved. So that is why I told that it is based on the intensity of infringement.
Okay. Thank you very much, sir, because this entire issue came to my notice when we were, looking into the whole issue of generic drugs and how multinational corporations were kind of, suing these companies.
Okay.
Thank you very much.
Thank you.
Sir, one more question. From Jayakrishan Divagaran. Sir, is there any department in government who advises the economic value of the type of patents? And filing patents for the sake of patents is of no value unless there is an economic value that can be derived from them.
That is true. Just filing for the sake of a patent is of no value, but you cannot blindly say that it is of no value, especially in academic forum. You have a lot of credit over that, so that will be counted for your promotion, maybe your higher career aspects and other things in that aspect. Now, coming directly to the kind of business oriented this thing, even though it has no value, that is why we say you file a patent, because that gives you a lot of recognition. Now, depending upon the worth of the patent, that means there is a value of that patent, how much valuable that patent is, and where it is valuable. Suppose you make an invention, maybe just to give you a small example, maybe for an arecanut dehusker. Okay, it may be a small technology. It has got application only maybe in our South India or maybe whole India, you can say. Of course, this is not a vast example, small example. There are ifs and buts. So you take a patent only in India. Okay. That is enough. You need not file a patent in US or Singapore or anything. But suppose you have something invented related to your mobile phone technology, or artificial intelligence, or even drugs, etc. Then you should understand that it has got vast potential. So what is the worth of your patent? That has to be estimated and evaluated. So that comes under the broad category of technology transfer. Technology transfer, of course, there are central government institutions like DST, TIFAC is doing, here our ACST is doing. So we are there to support that kind of aspects. I hope it is clear.
Thank you, sir. And one more question, sir. Suppose I want to fabricate an equipment and patent its design. Will we get any financial assistance from KSST?
That actually, I told you, see, that depends upon, we have a policy. We have a patent policy, IPR policy, in which we are giving two kinds of financial supports. Number one, if it is from an institution, suppose you are, of course, if you are a faculty, if you file a patent, it should be, just 1 second. So it should go to the name of All Saints College. And if so, we have a corridor through TIFAC, we can get it patented, and you need not have to bear even a single paisa. Full cost is absolutely free. Free of cost, that will be filed. That is the case of an institution. If it is an individual, then if you are economically weaker, then of course, definitely we bear the cost and file patent for you. And if you are financially sound, then we have a patent attorney, official patent attorney, and is providing lowest rates for filing patents. Through that service also we are getting to you for filing the patent. So with the lowest expenditure, you can get it filed. I hope it is clear.
Yes, sir. It's clear.
Thank you.
Any more questions?
Any more questions, please? Because time it is already over.
Okay, then, sir, now I invite Ms. Shirley Joseph, the Head Department of Mathematics, for proposing the vote of thanks.
Thank you, Anjana. Good afternoon, all. It was really an informative session, sir. On behalf of the IQAC of All Saints College, we extend our gratitude to Dr. Ajit Prabhu, sir, Chief Scientist of KSCSTE and Nodal Officer, Patent Information Center of Kerala, for taking the time to host this wonderful session. Thank you, sir. Also, I thank each and every participant for attending the session. Thank you all.
I especially acknowledge Dr. Anjana's involvement in this webinar, national webinar, and among the management and the team, she has taken a key role to organize this webinar series on a very, very pertinent subject. Due appreciations and regards from KSCST. Thank you. Thank you.
Thanks. Now we can have the third session. Now I welcome Dr. Lekha Rani, Head, Department of History and Political Science, to give the welcome address.
Thank you, Anjana. Am I audible?
Yeah, you are audible.
Good morning to one and all. Dr. Deepa M., Principal of All Saints College, our guest of honor, Dr. Lisa Joseph, invited speakers, colleagues, and dear friends. It gives me immense pleasure to welcome Dr. Lisa Joseph, Senior IP Analyst, Royal Philips, Bangalore, to today's national webinar to speak about IP protection for academia. I would like to give a brief introduction about Dr. Lisa Joseph. She has completed her BTech in Electronics and Communication from CET and MTech in Computer Science from NIT Warangal and PhD in Computer Science from University of Kerala. Trained in ICTP, Trieste, Italy, Hague, the Netherlands. She has worked in ERDC Trivandrum and in the Computer Science Department of University of Kerala before starting her career in the research division of Philips later. As the group manager of the global IP analyst team of Philips, she has more than 15 years of IP-related experience. On behalf of all IQAC members and all those who are present here, I extend a warm welcome to you, ma'am. Thank you. Over to you, ma'am.
Thank you. Dr. Ajit Prabhu, can you please come out of the presentation? Can you see my screen?
No, ma'am.
Let me cancel and see. Can you see now?
Yes, ma'am.
Okay. Thanks. At the outset, let me thank Dr. Anjana and Dr. Deepa for giving me the opportunity to talk at the webinar conducted from my hometown. 2 decades back, as a member of the Board of Studies in Computer Science and also as a member of the Academic Council of the University of Kerala, I had helped making changes in the syllabus of various courses. But IP had never come into our radar. I'm very happy that IPR finds a prominent position now in the Indian academic field. You can see my screen?
Yes, ma'am.
And am I audible?
Yeah, ma'am. It's audible.
Okay. Okay, thank you. I would like to take you all on a quick walkthrough of the why and the how the academicians can and should take protection from the intellectual property rights. Definition of IP is the category of property that includes intangible creations of the human intellect. It has been mentioned so many times in the previous presentations. In a nutshell, it is the creations of the mind. In the current scenario, the academicians don different types of hats, like learning unfamiliar technology, like presenting video presentations, fund management, administration, etc., etc. We are in an environment where our actions and intellectual assets need to be protected while wearing the different glasses to get the different views. So I renamed the presentation as IP protection for the IP, that is the intelligent persons. So that is why My grandchild is wearing the different glasses. During the almost 2 decades that I was at the University of Kerala, I also have gone through the mindset that IP protection is irrelevant for academic research. The common attitude is, why should I care about patenting my idea or an invention which makes me wait years for publication of my research results until patent is granted? I can get it published right away in a journal to get peer recognition, promotion, and all the other fringe benefits. After a long wait, the stigma of getting the patent application rejected also can happen. Hence, the publish or perish axiom is deep rooted in the academic community, as I also had experienced. Now, what I find is we, the Indian academics, are chained by various invisible chains like funding, promotions, lack of encouragement, etc., that we still believe in Bernard Shaw's script that those who can do, those who can't teach. Am I right? Many of the academicians here are teeming with creative ideas, I know, that will prove to the world that the quip is not right. But we actually want to hide under the impression that why should I patent or why should I protect the IP rights that I have? So wishing you all the strength to break the shackles and prove that you can all do and not just teach. If we have the so now coming to how to protect. If we had to protect IP, first we have to be aware of what are the types of IP. After 2 sessions, this could be redundant information that I will be sharing, but we will look at it from an academician's everyday perspective. The basic type of IP that are protected for academics, for everyone, are patents, copyrights, trademarks, trade secrets, traditional knowledge, and geographic indications. So you have already heard about how these are protected already, but still, from an academician's perspective, how we can view this, I'm going to be. So we'll just have a cursory glance at the trademarks, trade secrets, traditional knowledge, and geographical indicators, because basically as academicians, we'll be having to protect our patents and copyrights. The IP rights protection categories successfully have made so much of noise. These days, most of us know about these. That is the trademarks, trade secrets, traditional knowledge, and geographical indicators. So just see, if you look at the trademarks, it can be word marks. This has already been taken. So like Microsoft, Philips, etc., this can be just word marks. But even here, the shape, the color, and the aspect ratio of the characters do matter. To tell you a secret, usually Philips actually has got piracies. They detect piracies by finding that the font or the color in which the name Philips has been spelled on the products is not right. So, it can be symbols or pictorial representations. You have seen all these symbols already, like the famous ones. There is a Mammootty joke which says, while driving abroad, they are always looking for the manjana to eat because that is where you get good food at cheaper rates. So later, actually this manjana, which is nothing other than McDonald's symbol, we have found that this has actually saved us a lot while driving through from getting into McDowell's, which actually has got a red colored in that. So now coming to traditional knowledge. Traditional knowledge has a potential of being transferred into commercial opportunity, providing useful leads for development of products and processes which can be IP righted. So if you look at this, USPTO, we all have known that USPTO has revoked a patent on turmeric because the patent was applied for powdered turmeric and it was for the property of healing of wounds, which has been known for quite a long time. And this actually takes it to the academic patent right that Sri Chitra was trying to take up. And you all know that there was so much of hue and cry about Sri Chitra's patent being rejected at USPTO. But you see, basically, initially what they had tried to protect was the property of turmeric to cure cancer. So that is something that was known, and it's like discovering something that was already there. But later, you may know that when they gave sufficient disclosure as to what they are trying to protect, this has been actually taken for searching by USPTO now. And if you look at another thing, you will see that RiceTech, the American company, holds a patent on basmati rice. So it was granted in 1997, and all the traders from India and Pakistan actually revolted because it put it on hold their claim to distribute basmati rice, because RiceTech actually had held the patent for that. But then India government and WTO also intervened, and it had to withdraw 15 of the 20 claims that it had filed. And RiceTech also had to change the title to Rice Lines BAS 867 as the title of the patent. And the products have been rebranded from basmati rice to Texmadi, Jasmadi, and Kasmadi. So much about the power of patenting, protecting your IP rights. Now coming to trade secrets. These are also like the Coca-Cola trade secret is the one that has been actually like everyone knows that there is a trade secret behind Coca-Cola, and this trade secret has been, the folklore says that this trade secret has been put into a locker, and the locker has got something like N different locks, and the keys are with other people, and so much of folklore we all have heard. But what we have not heard is actually two employees stole the trade secret. One was working in Coca-Cola, and he knew the composition. He stole the trade secret and tried to sell to Pepsi. So based on ethical grounds, Pepsi reported the offer to the IPR department. And in 2007, these two employees were arrested and they were fined. The next one, the example that I would like to give about trade secrets is Google's search algorithm. So this uses an algorithm that ranks the websites based on factors like inbound links, page ranks, relevant text, etc. And this is basically a trade secret. Sometimes we get vexed when Google tells us, okay, this is what you are trying to search, when we are not actually searching for that. But you know, you cannot actually use the Google search algorithm for yourself because it's basically a trade secret. But if you want, you can make another algorithm based on what you feel should be possible, and you can try to put it as a trade secret. Now coming to geographical indicators, again, you have seen this, Aranmula, Kannadi, and near to home, Balramapuram sarees. These are actually protected by us geographical indicators. Now getting to see what we can protect as academicians. So you have seen the inside, outside of this IPR rights protection already. But as academicians, what are we going to see? How are we going to benefit from copyrights? So copyright is just a legal device that gives exclusive rights to an original work of creative expression expressed in a tangible form. This tangible form is very relevant because you might be remembering about the fight between Ilayaraja and some of our musicians, because the lyrics that were written by Ilayaraja and tuned, this actually can be falling under a literary work. So this can be patented. So when you're singing it, just when you're singing it without recording it into a device, it's not a tangible form of creative expression. So it does not become a copyrighted thing, just the thing singing that you are doing. So that is why these things were like matters of fights. Now for the IP produced by academics, such as print publications, the thesis that you publish, these things can be copyrighted. So since Professor Ramakrishna has already talked about in all this in detail, we are jumping to the next slide. Now, how to get a copyright in India? So this also has been covered already. And only the last line could be of interest to us. Copyright expires 60 years from the end of the calendar year in which the author dies. So that actually means that it's the author's life plus 60 years. So this also has been covered. And copyright, you see the C inside the circle on top. So that is a symbol that to see that something has already been copyrighted. Now, how to get a copyright in India? This also has been detailed by the previous speakers. Now, this slide could be of interest to us, the academicians. This shows the exemptions to copyrights. See, I think someone had asked a question also. If you already have a figure that is there in a book, can you use it for your private study? Yes, you can. For the purpose of research or private study, even copyrighted articles can be used. And these are the exemptions to copyrights that you can use. The funny thing is, in Philips, though we have been in the IP rights business from 1923 onwards, there are times when we have to actually download articles or journal papers which have been published with a copyright, which have been published in a copyrighted journal for our search purposes. You see, something that we have found is, since this is going to be for research purposes, we can download the paper, the copyrighted paper. After 1 or 2 days, the downloaded thing simply expires and it vanishes. So in the beginning, we were wondering why this is happening. And then we realized, though we have been dealing with all these things, the practical knowledge is something that comes very rarely. That because of these exemptions to copyrights, we were able to download these things for our studies. But after a few days, it automatically actually gets withdrawn. Now, talking about the patents. This also how a patent can be applied, what it implies, and all those things you have already seen. So now I'll just provide whatever is useful for the academicians. And I will try to express this using some examples. So the patent provides a legally protected monopoly and territorial rights for a fixed time period. See, all these words in the sentence are important. It gives you a protected monopoly. So once you have patented your invention, you can actually use the result for yourself. So it gives you an exclusive right to whatever you have patented. But however, it's only a territorial right. Meaning, if you are going to patent something in India, your patent right remains only in India. So if you haven't patented it in any other country, say in China, and if someone uses it in China, you just cannot complain because you have never thought of actually patenting that in China. But of course, later you can apply for a patent there. That's a different story. And another thing is it's applicable only for a fixed time period. And fixed time period is only 20 years from the time you file the invention patent application. You see, this is something like that, not a predictable thing. You file a patent application and it can take any amount of time depending on your luck to get it granted. So sometimes there have been cases where a patent is granted only 15 years after you have tried to file the application. So your the money that you may get will be now for the 5 years. And the rights that you get, the monopoly that you get is now only for these 5 years. Sorry, money is not for 5 years, but the monopoly that you get will be only for the remaining 5 years. But let this not be a deterrent for you, because in later slides, I'll tell you how the money-making thing of an IP actually extends beyond these 20 years. Now you see the story that Philips came into existence in 1891 only because Thomas Alva Edison did not care to patent his invention of light bulbs. It's a lighter thing that we all used to say. Because we were earning our bread and butter only because of this forgetfulness or carelessness on part of Thomas Alva Edison. So, but you see, there has been a very difficult year in which Philips could float only because of the revenues generated from the IP rights and not from the products that it had generated. For a long time, Samsung had been in the radar of many IPR related companies. But you know, Samsung had been a very slippery eel. Since litigation is very expensive, and since it is the plaintiff who should provide proof of infringement of the patent right, by the time an infringement suit is ready, Samsung will withdraw the product from the market. So that was how Samsung used to exist and succeed without much of infringement cases. And you all know about the infringement case that Apple had filed against Samsung. You see, finally what had happened is the court, federal court, found that Samsung's tablet was much inferior in quality to Apple's, that Samsung has not infringed on Apple's IPR. And they simply got scot-free. Now coming to these Chinese products, we all think that the Chinese are actually infringing on the products, and then like they are getting into the IP rights, stealing the IP rights of everyone and making products. But I have heard the story once. Someone asked the CIP of Philips why the Chinese are actually making so much of inroads into IPR, why India, who is a set of people who are much enlightened, does not get that much this thing. He was telling, you know, in China, actually from first standard onwards, kids are made to study about IP rights and how they should be protected. So mostly what happens with these Chinese products is there is actually a leeway to the IPR rights. That is, if you have a product, you can actually go for something that is called a workaround. So you are going to be doing something that is already available as a product, but if you break the product and look inside, it's going to be the circuits are going to be different, the algorithms that are used could be different. So it could be an inferior product, but it could be an economical product, and they may not be infringing on the IP rights of people. So these are some certain things that we academicians should be aware of. And if you take the case of Fair and Lovely, this is a very typical case of the IPR rights for available only for a fixed time period. This skin whitening product took Indian markets by storm in the 1980s. I remember while in the hostel, many of my friends were using Fair and Lovely, and it enjoyed a monopoly in the Indian market. But as soon as the 20 years of protection period was over, the market was flooded with skin whitening products. So Fair and Lovely still holds a small share of the market, but so many others have come in the market with maybe better products, maybe costlier products, but still, this is what happens when the time period of 20 years is over and the product is there as a free for all. Now, this is a common misconception that most of us academicians have, that a patent needs a scientific or engineering base. If you want to have a patent, you need at least a scientific background or an engineering background. This is not true. Just see this patent, a date picker in Excel sheet. So this example shows a patent granted to a person who has adept at handling commercial data. And this one shows an example of, see this one, floral design container system. And this one shows an example of a patent granted to an artist. So you see, the patenting technology is actually not a rocket science. Any of us who have got some creative ideas can patent the ideas. Now, for example, while looking for this, I came across a patent, which is JP6151011, whose title is Instant Curry and Manufacturing Method. The claims also say that it's a vacuum packed with resin sheet material, but still basically it's about how to process curry and curries using a different method. And you know, there is a CN patent, Chinese patent, whose title is Curry Sauce for curry chicken and preparation method thereof. So you see, anyone can patent. Now you see, we have in all the previous two talks, we have heard about patentable inventions. And all that it needs is novelty, utility for this thing, non-obviousness, and in US they say enablement or sufficient disclosure. Just look at this patent, this thing that is patented. When you go out in the rain, you hold either an umbrella or you wear a raincoat. Both protect your body from the rain. But what about your shoes? It does not get protected. So basically, this invention, it has got novelty because it's protecting your shoes. Actually, I have seen something which can actually replicate this, because in Venice, when the water rises, people all wear just plastic bags over their shoes, which protects their shoes. But this one actually looks good also. So it has got novelty. And doesn't it have utility? Yes. It protects your good shoes from getting drenched. And isn't it non-obvious also? Because people would have thought about wearing a plastic bag over your shoes, which takes away the beauty of your shoes. This one does not take away the beauty of your shoes also. And the umbrellas look so cute also. And enablement, that is, when you are filing a patent, in India also actually it's applicable, though we don't actually declare that this sufficient disclosure is needed. So they had mentioned how to make this also. But the thing is, why do we want to patent something? I saw a question raised by someone in the previous session. How do we find out about the economic value of something? And you see, if something does not have any economic value, why do you have to patent it? See, who is going to buy this thing, which actually was patented? This was actually something that was already patented in US. But who will buy this? Then why should you want to actually go on spending dollars, rupees, euros in just for having a patent right on something like this? Now you see, this is something that has been making a very big hue and a cry in the patenting, in the IPR fields, software inventions. You see, can we patent an algorithm? After all, an algorithm is not actually related only to computer science. Though in computer science, we started calling the steps to achieve something as algorithms. It can even be the, say, how you apply makeup. That can be actually called as an algorithm. Because if you are going to apply powder before applying foundation, then that is not the correct sequence that has to be followed. So basically, you can actually make an algorithm even for makeup. So you see, algorithms per se just cannot be patented. But you can patent the series of steps in your algorithm. So mathematical steps and procedures can be patented under US patent law. But it's not that easy when it comes to Europe. So it's very tough to patent machine learning and AI algorithms since these are considered to be abstract ideas. A machine learning or AI algorithm is likely an abstract idea if it falls into a mathematical concept, a method of organizing human activity, a mental process, etc. But see, since machines are patentable, embedded systems that enable machine learning or AI are patentable. So that is how the robots actually become patentable. Now, DNA products. DNA products are patentable in US, subject to when it's isolated, purified, or modified to produce a unique form not found in nature. So you all could be remembering the controversy over cloning and Dolly the sheep, which was produced by cloning. See, even in US, the patent was not granted because the DNA of Dolly was actually identical to the animals from which the DNA was copied. That is the. Now you see Monsanto's GM cotton seeds. There has been a hue and a cry in India also about patenting Monsanto's GM genetically modified cotton seeds because by Indian patent law, patenting of plants and biological matter are prohibited. However, this has been actually going to us and back and forth. That is, it got revoked, then it got reinstated because basically the argument was genetic sequences generated in the lab can be patented. Okay, so now these are the channels for transfer and diffusion of academic knowledge and patenting for as far as the academics are concerned. We have publications, presentations in various conferences. We do sponsored research and R&D collaboration with firms. And sometimes we have an idea and we give those to do the postgraduate projects. And the staff take up consultancy work and spin-off and startups are also done. But see, as long as the poor man's patenting concept is not available in India, better to go for IP protection before getting to any of these channels. It may delay it by maybe a few months, but I think that is tolerable because if you go for an international publication, what I have found is my IEEE publications always had to wait at least for 6-7 months to get published. So in that case, if you are going for serious publication, maybe it takes quite a lot of time. So why don't you just give it a try at protecting the IPR also before publishing it? As far as patenting is concerned, or IPR protection is concerned, see, you can jump in the presence of all public. You can have an audience, and you can, when you take the plunge like this, it will give you a glory, but that glory is momentary. But being patient and protecting the IP will keep that glory forever. So basically what you should do is, the invention should be novel. Just see, ideas just cannot be patented. You may have some great idea. I remember that in childhood when we were playing, when we want to cheat, I used to tell my brothers, okay, this is something that I am going to patent. So this is something new, which is I am going to incorporate into the game. See, something like that is not patentable. An idea just cannot be patented. It should have actually sufficient disclosure as to how it has to be done. And that only then it becomes patentable, and only then it can be protected. And see, there should not be any public disclosure before you try to protect it using the patenting. This actually has happened several times, even to me. Because once you have a paper ready, you actually try to publish it as fast as possible. And after coming to the IP field in Philips, I have found that sometimes your patenting application is rejected because of your own publications elsewhere. But you see, then how do we actually get, like, I have an idea and I have done something regarding that, but I want to get some expert opinion also about that before I publish. So that means if I am not allowed to have any public disclosure, and if I'm going to be keeping this only to myself, how do I get the opinion of others regarding this? See, there is actually a loophole. Public disclosure does not mean that you are not going to present it to a selected audience and this is not going to be available in the public domain. So as far as it's not available in the public domain, and if you have signed, if the people who are going to be attending your presentation have signed an NDA, then actually you can try to get public opinion, expert opinion. But please don't disclose the key features of the invention to others before you try to patent. Now, you see, if you have to actually come out of the publish or perish mentality, there should be an institutional IP policy to deal with. And I understand from Dr. Ajit Prabhu's talk that Kerala also has been actually trying to do things about how to guarantee the ownership and rights of use of the IP to the people who have invented it. And what are the procedures for cooperation with third parties? So I think the IP cell in Kerala has been doing something about this. Same organizations which have been dealing with protection of IP for a long time. There are procedures for identification, evaluation, and protection and management of IP. And how the ownership goes, that is also like detailed and documented in such organizations. So you see, matured organizations always have an in-house IP policy. For example, if you take the IP department of Philips that came into existence in 1923, the policy is that if possible, employees of the IP department should not directly get involved in submitting inventions online. This is because you get to know what exactly the others are doing. So if you are going to be using that for your own use, that's not ethical. So that is why something like this is there. And if you are submitting an invention and if it gets granted, you get a lump sum money because we have been using the facilities that are offered by the lab in which we are working. So usually the product and the IPR becomes the right of the company or the organization or the institution in which you work. Then comes the question, why should I patent? Why don't I just publish? So the first thing that comes there is funding. So in US and UK, the industry academia partnership is fostered through legislation. But I don't think in India, it has been protected by legislation. But I hope in the near future, it will be protected by legislation in India also. And the recognition that comes with patenting something, that's actually really great. Much, much more than whatever you get by publishing yours. The first time I went to Netherlands and we were going to visit Leiden. And the thing that I remembered is, okay, I had never seen this place, but I have heard about this place. Then I remembered in college classes, I have read about the Leyden jar. So you see, this is actually a patent that was held by someone working in Leiden University in 1911. We don't remember anything about the inventor, but we remember the name Leyden, about the Leyden jar. And the first time I visited the Philips headquarters in Eindhoven, I was wondering, where have I heard about this name Eindhoven? Then suddenly I realized, okay, I've been learning about Eindhoven triangles that are used in ECG for a long time. So you see, your name, the place name, whatever you choose, and in your IP invention, that actually becomes etched in the memory of people. By the publications that you have, those are actually like, that gives you a glory for maybe 1 month, maybe for 1 year, not after that. Now what I find is, AICT and the Commerce Ministry has come up with a proposal in September 2019 to share the patent rights with students for on-campus inventions. And it has also made it mandatory for academic bodies to share patent rights with a researcher if the facilities of the institution are used while developing a product or a technology. And I understand that this is also extended to students, researchers, and faculty members. So now, as a conclusion for my webinar topic, I have put as food for thoughts. You see, you are the custodians of knowledge that increases while getting disseminated. In Malayalam, we say, "Kodukkundorum eridum." So that is the thing that you have in your hands. So please come out of the shell of patents are irrelevant for academic research, and bring out the pearls in each of you, whether you are working in science field, in humanities, in commerce, or in language. See, there is a pearl of creative ideas within you. So please come out of your shell and disseminate and transfer the technology using innovation, protection, and promotion. So thank you. Questions?
Ma'am, thank you for the informative session. And questions, any questions? I'll read out the questions from the chat box.
Yeah.
Ma'am, the first question is, in academic research, other than application research, does descriptive research or exploratory research has any potential for patenting? For example, a novel methodology developed.
Okay, it's a novel methodology that is developed. So that actually comes under a patent for a method. So you see, like I said, you can even make that into an algorithm. But as algorithms per se are not patentable, you cannot patent it. One thing is you can actually copyright it. This I am actually telling from my experience, because my brother was telling me the other day, this is in commerce. He had come up with a formula for something to do with stock markets. I don't remember what it is, because that is not my subject. Since he had just published it, he could not get IP protection for that. But he could have actually copyrighted that particular formula, and that would have given him IP protection.
Okay.
Is that answer clear?
Okay, ma'am. Thank you. Another question. Has cancer treatment in India become less expensive on account of the 20-year rights expiring on a number of chemotherapy medicines?
Tough question, because one thing is I'm not the authority on pharmaceutical. But one thing that I can say is, have you heard about compulsory licensing? Actually, it was like P.H. Kurian, who was the patent director, who's a Malayali, who was actually instrumental for that. And what he had done is, sometimes patents that are held by foreign companies, they have a right to that patent, and they won't manufacture the thing in India. They will be manufacturing it out abroad, and then they will be importing that to India, and the price goes much higher than whatever is warranted. So by compulsory licensing, what can be done is the patent that has been that is not manufactured in India, that is not utilized in India, that was actually made available to Indian manufacturers, and they could also sell the generic drugs also based on this compulsory licensing. So that had brought up the cost of those medicines very less. And another thing is, after 20 years, see, a patent actually has to give you everything about how we are doing that. So after 20 years, that knowledge becomes public domain. So anyone can use that knowledge, one thing. But you see, just because I say that anyone can use that, the infrastructure that is needed to make use of that knowledge, that is not going to be very cheap. And before 20 years, you're not supposed to use that also. And you see, even when we say sufficient disclosure, there are certain things that are not conducive to research in that. And there are certain things that are not like available, like maybe a small thing, like how the equipment is like configured to make something, or the number of hours that are used to do this. So these things need not be disclosed. And until and unless these are disclosed, people may not be able to actually use the disclosure to their advantage. Does it answer your question? Or did I go outside the purview of the question?
No, ma'am. Thank you, ma'am. So, ma'am, one more question. In India, there are a lot of hackathons and invention competitions where students and faculty just describe their innovations in public without properly securing them using a filed patent. What are your suggestions in this aspect?
Okay, as an ex-employee of Philips, who has been conducting hackathons for a long time, I have this personal experience. We usually get something like more than 500 ideas, which can be called as inventions. So what we do is, all these, we actually try to run a novelty search. And if something we feel is there, which we feel that is quite novel, which has got business applications, then what we do is we won't allow that to be actually showcased in the hackathon, because this is something that could be actually potentially which could be producing revenue. May not be for Philips, because Philips may not be interested in that idea, but maybe for the person who was trying to actually do this. So what I will suggest is, it's always good if you come up with an idea, it's always good to talk with someone who is an expert in the field. That's why I said, see, if you want to get your IPR protected, you will need this to be kept confidential. But on the other hand, you may want to get protection. You may want to get expert information also on that. So how do you do that? Unless you can actually get an NDA and you conduct something in a closed forum of experts, you won't be able to get that. So what I will suggest is, even in colleges, before you make public some ideas, better to get some expert opinion on that.
Okay, thank you. And another question, what are your thoughts on students and faculty learn to do a prior art search in their areas of work and interest, so that they will get an idea of how generic and specific claims need to be developed to get the best claim from the infringement in our patent?
Okay, so it's the infringement in our patent. So initially I thought, okay, I was actually rather happy that a question like this had come, because that was something that was earning my bread and butter. You see, in all the patent right protection, you have to know whether there is something that is available already. And in patenting field, we of course call it as prior art. While we are writing a paper or something, we call it as a reference, bibliographic references or something of that sort. So actually this question is, I think, divided into two parts. One is if we should conduct a prior art search and if people should be equipped to do the prior art search. Okay, prior art search, before joining the IP department of Philips, what I was thinking is prior art search is nothing but something similar to a Google search. Okay. And laterally I came to know that prior art search is not a very simple thing. It's not just a Google search. You see something that you had an idea about, this could be something that was available in Burkina Faso 20 years back. So how do you know about that? This could be something that was available in Greek that people knew at the time of the Greek civilization. Who knows about that? Google search does not give you something like about that. But unfortunately, the patenting office will know all about this. So the invention that the patent application that you are filing could actually get rejected because of this prior art. So that is what about prior art. But still, we are doing a prior art search on Google for available literature will be a very good idea, because that is actually something that we do when we have when we write papers or when we do our PhD research also. You see, at the last moment, you may find that whatever you have been trying to do for the last 20 years is something that has already been done by someone, and they have published papers also. Then all your research goes for a toss. So something similar to this can happen for patenting also. So that is one thing. And the second part of the question was about infringement. Infringement is basically about someone tries to do whatever you have been doing, one thing, but you have already protected your IP. So how do you make sure that they are not infringing on your patent? A very difficult situation. Because you see, if you are trying to give an infringement suit, if you are trying to file an infringement suit, you have to prove that this person or this organization has actually made use of the technology that you have patented in their product or in their process. So it's up to you to make sure that they are doing that. So just by reading papers, it's not going to be possible to do that. You know, there have been cases where we actually take up iron box, open that, and see how the circuit works, and open a patent box, iron box, to see how it works, to see if they are using the patent that we have already filed.
Ma'am, one more question. Do you suggest students should start practicing TRIZ, a problem solving looking at the patterns in millions of patents?
Okay. I don't know, because the thing is I had never been a fan of TRIZ. If you ask me, I have used it. Okay. But unfortunately, I have never been a fan of that, so I'm the wrong person to answer that question favorably.
Okay, then another one. Can you highlight compulsory licensing?
Highlight in the sense, okay, what exactly do you mean? Because I think that question was asked before I started talking about PhD and making compulsory licensing for medicines in India. So if that question still persists, then okay. Okay, that was from Jayakrishan, and he says that I have already explained.
Okay. Then
by the way, I am actually a fan of PhD and all the Malayalis who are working in the patent field.
Okay. Then another question is, why is there a protest against BT Brinjal?
Okay. one thing is when you are genetically modifying something, and especially about Biti brinjal, what had happened is, you see, you get the fruit or the vegetable, but how do you reproduce that? This is genetically modified in a lab. You may get a patent for that because it's a new thing. But what the farmers of our land need is, usually what I understand that what normally is done is, okay, you don't actually, my father used to tell me this, വിത്തിന് വെച്ചേക്കുന്ന അരിയെടുത്ത് കഞ്ഞി വെച്ച് കുടിക്കുന്ന മണ്ടത്തരമാണ് കാണിക്കുന്നത്. So basically, over the years, what used to happen is, you will reserve some good seeds so that the next generation agriculture can happen. But you see, when you have something, the seeds of which just cannot reproduce or which does not have any seed at all, what is the point in having something like that? You can have something for a year, but what do you do for the next generation thing? It's a very, very difficult situation. And somehow I feel that that is a very unethical situation also. Okay, it's a personal opinion. So,
Okay, any more questions? Okay, ma'am, thank you. Now, I invite Dr. Sonia Nair, the head Department of English, to deliver the vote of thanks.
Good afternoon. I would like to remark that this was an exceptionally energetic presentation, and you spoke with a great deal of passion and spontaneity, ma'am. There were so many ethical concerns addressed, and there was so much of contemporary relevance. And I, on behalf of the IQAC and the other office bearers of All Saints College, I would like to thank you for a very informative and captivating session. You shed light on the details of patents and companies and how all of these things come about. And I think that one of the takeaways from your session is that we need to understand that there's an urgent need to incorporate IP rights into the curriculum of all courses. And you did clear up a lot of misconceptions about patents, especially in academia. And with the changes that are coming in the implementation of the NEP, these concepts become indispensable. So I would like to end my address with these 3 words that I have taken from you, and I'm sure they are patent pending now: innovation, protection, and promotion. Thank you very, very much.
thank you.
Thank you, dear participants. And the feedback link is provided here, and you will be receiving the certificates only within 2 weeks. So kindly bear with us. Okay, thank you very much for your participation. Thank you.